For orders, I can work.
Nói mỗi phim chưa
Yes.
Item 1.
Yes, but the last order, my learned friend was to respond on the affidavits that we have filed.
Where is the amicus?
Your name, my senior R.S. Chaudhary is absent today, Lordship.
Mr. Das is the amicus.
Yes, yes.
He is not present.
I please, your lordship. He is coming, lordship.
Meanwhile, Lordship may
Yes.
find out from the registrar, my lord. In fact, the last paragraph of this order, last order says that Mr. Swenso Land Registrar Administration Guwahati High Court is therefore directed to call for reports from all the district judges in the state of Assam as regards the following. Number one, the cleanliness status of the toilets in all the judicial establishments in the district. Number two, whether the adequate toilet facilities available for the women and persons with disability, PWD, in the judicial court, bar association buildings of their respective districts. If not, whether there is scope of creating one in the near future. And thirdly, what is the procedure adopted for regular maintenance and cleaning of the toilets? Possibly.
So it appears that almost nowhere there is toilet for persons with disability. That is not there.
My lord, these buildings were constructed long back, my lord, in most of the establishments. So Lordship in my humble opinion, Lordship may make a general observation that in future, all the construction that are undertaken should be in consonance with these requirements. So for as toilets for the persons with disabilities concerned.
So otherwise, the report says that everywhere the toilets are clean regularly, etc. That appears to be the. Have you seen
On the last Lordship's recall, I shared my own experience in the. So there something more is required to be done. I'm not saying that nothing is there. Something more is required to be done. This is one area where
See, it is not about toilets.
no,
It is about,
general cleanliness.
It is about
hygiene.
maintaining a hygienic work condition in the judicial establishments. So toilet is an integral part of it.
Integral.
So the administration will have to look after it. Who else will look after
Madam.
it? Now, what is your suggestion in this regard?
Well, that's what I said. Lordship may make a general observation and circulate to all the districts. These are the minimum requirement that they should follow. And my personal view is like this, my lord. So far as the, I do not know about the buildings maintained by the registry, but in other places, my lord, if it is outsourced and a proper vigil is kept on them, I think better result.
No, but do you need a judicial direction in this
No, well,
regard?
for a-
Toilets are to be
my
cleaned
lord,
regularly.
I'll request Lordships, my lord, that let a general survey be made over the positions prevailing in Guwahati. This is,
No, this report doesn't cover Guwahati.
I do not know. my lord. We will come to this.
Sir, it covers. It covers all the districts, madam. Eleven and 12, my lord. 11 is Kamrup Amingaon. Then 12 is Kamrup, 13 is Kamrup Metro.
So where are you getting the serial numbers? No number is there.
A page number, my lord, down below page number. I'm sorry.
Yeah.
Down below, there is page number.
Where is page 12 here?
Hmm. Third one. That's it. Itu Aziz. Oh. Fine.
Lordship is having the bunch with office note dated 8/1/2024 in the front page. Pursuant to the order under reference.
Hmm.
This is,
Yes, yes.
Annexure 1, then page 11 is the Kamrup district, Kamrup Amingaon, my lord. My lord, I have seen the report, my lord. The situation is very pathetic, to be very honest, my lord. No,
Public.
sorry, my lord.
No toilet for public.
No toilet for public, no women toilet. PWD, I, you know, let off. No toilet for women, my lord. I don't know whatever scheme the state government applies, Swachh Bharat or anything. Look, these are to be there. My senior has made a suggestion that all future construction, this facility, my lord, future we'll see later. Let us be practical in the present time, because without this facility, I am grateful to your lordships and my learned senior friend R.S. Chaudhary, who also, my lord, brought this aspect. And we are now getting a larger picture of the small issue. Now, every district, your lordship will find no toilet facility for women, my lord. Almost all the districts. So immediate measure has to be taken to, my lord, construct the facility, toilet facility for women and PWD. Whatever scheme they apply, that is for the government to see, my lord. At the same time, another aspect is that the government also has to provide manpower for maintenance of the toilet also. You know, erecting a toilet is one thing, maintenance is another big task.
Who registry,
My-
register admin, yes.
Yes, my lord.
Do you understand the
Yes,
reason
my
why
lord,
this court has,
Yes, my lord.
it is not to supervise toilets.
Yes, my
It
lord.
is to see that there is a clean working environment maintained in every judicial establishment.
Yes, ma'am.
So that is the task of the registry.
Yes,
That is the task of the administrative bodies. And so what is your suggestion?
My lord, we will instruct the honorable district judges of the
Hmm.
concerned district to outsource the cleaning staff, my lord.
Where is the fund?
It will be required to be created by the government, my lord.
So that means if the fund is not given, you can't do anything.
Yes, my lord. Difficulties there are.
Let them come up with a formal position. And right now, what is the position that must first of all disclose? How it is going on? Whether there is any scarcity of fund or not, that has to be seen straightway, my lord. This conclusion cannot be drawn that there is no fund at all.
All right. And what about the other aspects?
My lord, the other aspect is that the infrastructure issues, wherein, my lord, last occasion also, we have given a chart of 10 courts, wherein the infrastructure facility, we have appointed judicial officers, but due to, my lord, the infrastructure facility, unavailability of infrastructure, we are unable to provide, my lord, facilities to the judicial officers.
Which are the,
10 districts I have, my lord, given on the last occasion. Bojali, Biswanath, Kachar, Silchar, Soraideo, Hojai, Kamrup, Metro Special Judge, Majuli, Morigaon, West Karbi Anglong and South Salmara Mankachar.
no, first of all, the affidavit has been filed by the four chief secretaries.
Yes,
Have you examined those?
yes, my lord. One affidavit has been filed.
One affidavit.
My lord, pursuant to the last status given by the registry. There is a, my lord,
No, Mr. Das, please
I'm sorry.
look at the last order of this court.
Last order.
Do you have the last order?
Yes,
11/12/2023. So have you gone through these affidavits?
yes, my lord. In the affidavit, if your lordships kindly turn,
Hmm.
they have given the details. Page 1212, my lord.
Where are the affidavits? So, Mr. Das, as far as I remember, we had requested you to make a tabular representation of all the four affidavits and tell us which are the areas specific focus is required. Have you done it? See the order, last paragraph of the order. Similar exercise, please read it. Where is that?
My lord, I'm sorry, my lord. That is not, I just missed this portion, my lord, in the order, my lord. I'm extremely sorry. But from their affidavit also, my lord, it transpires, my lord. What are the areas where, my lord, the emphasis has to be given? Because
So you want us to read the affidavit
No.
and find out for us?
I'll give, my lord. I'll give that. One page, my lord, short.
No, you please read this second paragraph of the order.
Yes, in terms of the order passed by this court, the Chief Secretary to the Government of Assam, the Chief Secretary to the Government of Arunachal Pradesh, Chief Secretary to the Government of Mizoram, and Chief Secretary to the Government of Nagaland have filed their respective affidavits indicating the status of construction of judicial infrastructure in their respective states. The affidavit on behalf of the Chief Secretary to the Government of Assam has been filed only this morning, and therefore Mr. Das, amicus curiae submits that he be given some time to examine the affidavits and place a consolidated report before this court indicating the areas where specific attention of this infrastructure bench will be called for.
So where is that report?
My lord, that report is yet to be filed, my lord. I was required to file that report, my lord. আমার তো report এখন নাই এখন কোনো নাই। মিটে একটা report কোনো নাই। হয়নি। বাকি স্টেট কি এখানে চাব লাগিব থাকা নাই।
Yes, Mr. Kashyap, have you prepared any report on the affidavits filed by the court?
No, Lordship, not yet.
No. Left it for whom?
We have prepared
You
the-
don't have any stand on the affidavit.
No, Lordship. We have
So we'll
prepared the
accept
report.
it and say that it is correct. No work has been done.
We have prepared the report earlier, Lordship, but not subsequent to the filing of the affidavit.
No, the four chief secretaries have filed their affidavits. The court mounts pressure on the chief secretary to meet the deadline. And when it is filed, the registry has no response to make. Then why should we ask them to file affidavit?
Sorry, Lordship. it was
It's
missed.
not a casual exercise going on. What is the order then we are to pass today? No order is required. They filed affidavit, it is not.
Yes, Lord.
So there is no response on what, whether the entries made are correct or whether it requires any judicial order or somewhere there is a fact which is not properly disclosed. How are we supposed to pass an order on that?
We are given some time, Lord Shiva.
Time is the only
within
thing
1
that
year.
happens. So, Mr. Majumdar, then the
Lordship,
matter
give
gets
them some
referred.
time, let them respond.
Prepared.
But another small issue with regard to Arunachal Pradesh is there, my lord. There is a report, a letter written by the uh, Joint Registrar PMP to the Honorable Chief Justice, and Honorable Chief Justice has asked this issue to be placed before this honorable bench. My lord, this is with regard to, my lord, release of fund by the central government and convening of meeting by the central government with the state representatives. Repeatedly, my lord, the state representatives are remaining absent in that particular meeting. It is about a fund of rupees 32 odd crores of rupees, my lord. My lord, details are there before your lordships.
This 32 crores is to be released by the state.
CSS, by the central government, my lord, under central scheme, centrally sponsored scheme, my lord.
Who remains absent?
The representative of the state government, my lord, in the meeting.
Why is their presence required?
My lord, for implementation of the scheme for allocation of fund in all these things, my lord, there was a communication by the central government, my lord, that your lordship will find there in the papers, which requires the presence of the representative of the state government in the meeting. And there was an observation that all the states, my lord, other states also given, my lord, letters. All the states appeared. Arunachal Pradesh, my lord, it has been said that
No, what we are asking you is, this is about allocation of funds by the central government.
how the funds will be utilized.
Listen,
Yes, I'm sorry.
This is about allocation of fund by the central government. So this fund is meant for judicial infrastructure.
Yes, my lord.
District judiciary or high court.
District judiciary.
So then they are not participating. So Mr. Goswami, what is it? Otherwise we'll say that we'll debar them, we'll debar the state from participating henceforth if they don't want to.
My lord, I, first of all, I don't have any instruction. A copy of the report may be given, my lord. I will convey it immediately. I do not know what is happening there.
So if they are reluctant, then we'll make it clear that they will henceforth not be allowed to.
Let me get back from them, my lord. Let me just-
All right. The presence is-
Highlights of the central.
By the order dated 11/12/2023, this court had requested the learned amicus curiae, Mr. H.K. Das, to examine the 4 affidavits filed by the chief secretaries of the 4 states, namely Assam, Arunachal Pradesh, Nagaland, and Mizoram, and thereafter submit a consolidated report. Today, when the matter is called up, Mr. Das submits that due to oversight, the consolidated report as called for by this court could not be prepared by him. He therefore seeks 4 weeks further time to do the needful. We also find that the registry represented by the register admin so-and-so and PMPO so-and-so also does not have any inputs on the affidavits filed by the 4 chief secretaries. Under the circumstances, it would not be possible for this court to pass an effective order on the status of infrastructures spread across the 4 states based on the claim made in the affidavits filed by the 4 chief secretaries. Insofar as the second issue of clean toilets across judicial establishments in the state of Assam, as flagged by the order dated 11/12/2023 is concerned. 11/12/2023 is concerned. The register administration has called for reports from the respective establishment health and thereafter placed the same in the format of a report. Full stop. We have perused the same. After perusal of the report, it appears that minimal toilet facilities are available in various establishments. However, the projection made as regards facilities for clean toilets for the women, persons with disability, as well as the litigant public, the report presents a dismal picture. Full stop. Situated thus, we are of the unhesitant opinion that the matter request to be pursued further by the registry of this court. As such, we direct the Registrar General of the Guwahati High Court to take note of the aforesaid report and thereafter come up with a concrete proposal for the future, not only so as to maintain clean and hygienic toilets for all the stakeholders, but also to ensure that adequate toilet facilities with proper maintenance infrastructure is available in all buildings of judicial establishments to be under construction or to be constructed in future. Full stop. The aforesaid exercise be carried out and completed, and a response of the registry be placed before this court on or before the next date of hearing. Full stop. Another important issue has been, you're right, the attention of this court has also been drawn to another important issue pertaining to the state of Arunachal Pradesh, whereby it has been pointed out that the representatives of the government of Arunachal Pradesh have repeatedly remained absent.
It doesn't say repeatedly, representative of state, this is with regard to one meeting 27-1. I'll get the
Have
instructions.
remained absent in the meetings held for the purpose of allocation of central government fund for construction of judicial infrastructure in the state of Arunachal Pradesh. Full stop. The learned amicus curiae has further pointed out that due to the absence of the key officials of the government of Arunachal Pradesh, the matter could not progress any further, as a result of which the progress of construction of judicial infrastructure in the state of Arunachal Pradesh has been seriously hampered. Full stop. If the allegation is correct, then there can be no doubt about the fact that effective remedial measures would be necessary without any further delay. However, on the request of Mr. B.D. Goswami, learned Additional Advocate General, Arunachal Pradesh, 4 weeks' time is granted to him so as to seek appropriate instruction and place the same before the court on the correctness of the aforesaid allegation. Full stop. The learned Additional AG to also appraise this court if the state government is reluctant to participate in the process initiated for development of judicial infrastructure with central government fund. Let this case be listed again on 18th of March. 18th of March.
My lord.
18th of
The
March.
second line, may I just put the second line, reluctance of this state cannot be there, maybe.
No, we are getting.
Because I have, notice, the other state also refrain. I'll convey this. I'll convey.
Right, add on one more line. We have perused the report dated 11/10/2023. Submitted by the, we have perused the minutes of the meeting held on 10/10/2023. As regards creation of judicial infrastructure in reference to CSS, what is CSS?
A centrally sponsored scheme, my lord.
Centrally sponsored scheme in Arunachal Pradesh. Full stop. তাৰপিছত এখন continue কৰিব। No, Mr. Goswami, we must tell you, we are getting repeated reports that there is no cooperation. Not reluctant, you're right. The learned Additional AG to also obtain instruction and appraise this court as to the reason for non-cooperation of the state government officials in the meetings held for implementation of CSS scheme
Fine.
in the state of Arunachal Pradesh. Officers are not coming.
Well, I'll come.
This is not good, actually.
Come. I understand. Madam.
And we'll find a way to do it. They're not. willing
Let me
to
get
come,
that one. Madam. Convey this one.
Then we'll pass an order.
Well, I may be
restricting them.
given a copy of this.
Yes, yes, ma'am. I'll find it during the course of the day.
Yes.
Much of them.
Please prepare the report, Mr. Dav.
I'm extremely sorry, my lord. For today, I'm extremely sorry, my lord. I'm extremely sorry.
All right, next matters.
Wait, I can wait.
May I please, your lordship?
Yes.
My lord, in this case, my lord, I'm having items 5, 9, and 28, my lord. And
Just a minute, just a minute. These are serious matters.
yes, my lord.
This is all education department.
Yes, madam.
Who is appearing? You are representing?
Education department, madam.
All right. So we are commencing the hearing.
From today, madam.
Of course. Why?
No, let's,
My lord,
because
I have some submission, my lord. My lord, in this case, my lord, and the provision we have challenged here, my lord, some items, my lord, learned seniors have leading these matters, my lord. Since they are, if I get information, they are not available today, my lord. So can it be posted on some other days, my
No,
lord?
it cannot be. Cannot be. We'll hear the matter. So many cases have been listed today. Sorry. Whoever is there, you argue. Seniors may have difficulties. But seniors cannot put a halt in the judicial proceeding.
It is
That-
true, my lord, but sometimes what happens, my lord, that senior advocate, that delayed, but
Whoever wants to argue is welcome to argue. You cannot put a hold to this.
my lord.
Item number 10, Lordship.
Hmm.
It is also secondary school, Lordship. And we challenge,
Who is going to lead the arguments here? Anybody is there to lead the arguments? Or else we'll reserve the judgment today. We'll reserve judgment. Nobody wants to argue.
There are different sections involved, so perhaps different sets of arguments would have been placed there.
Argue?
our school is, Lordship,
So
Secondary
which
school.
is your item? Which is your item?
10, item number 10, Lordship.
But what
Today's-
about item 1?
10 and
Item 2?
12, Lordship.
Item 2, who is appearing?
2 is also. Item
Who is appearing in item 12? Sorry, item 2, yes. Item 2, none appears for the writ petitioner on call. This writ petition stands dismissed for non-persecution. Yes, item 3, please. Who is appearing in item 3? Mr. Chaudhary, you are appearing?
My lord, I am appearing in 2 items, my lord.
Yes.
39.
Item number 39 and 53. Actually, my lord, all these matters are more or less interlinked.
Yes.
We are, in some of the cases, we have challenged the virus of the rules also. So if it is not inconvenient, could your lordship fix another date, my lord? Today I got some difficulty.
We'll accommodate you.
Yes.
But let us have a
Yes, yes,
feel of the matter.
yes, yes.
These cases have been listed before this.
Monday, certainly, my lord.
We
Certainly.
wouldn't like to just,
Yes, yes.
so
Deep-
you may,
Well,
yes, item 3. Item 2, we have dismissed for default. Yeah, no, but you are not present when the matter is called up.
my lord, I am here, lordship, I could not lordship here.
Yes, argue please.
My lord. Lord, in the item 2, lordship,
Hmm.
we have challenged, lordship, the provision that is here, lordship will find the provision 3.1, Roman 1, lordship,
What is it? 3-1?
3-1, Roman small one. That is space lordship 114.
Yes. One, 1-4.
My lord.
It is strike out to the order. Yes.
3-1, lordship, subject to the provision of Article 30 of the Constitution of India, the following categories of Bhansar educational institutions shall be eligible for being considered for provincialization of the services of their teachers and tutors. Now, the challenging part, lordship, is Roman one. The Bhansar educational institution which have been established and had obtained the required permission, recognition, affiliation, concurrence, as the case may be, up to the last and highest class required for the concerned institution from the respective competent authority or authority on or before 1/1/2006, provided that the order for such permission, recognition, affiliation, concurrence, etc. shall have to be issued on or before 1/1/2006, and any order issued thereafter with any retrospective effect shall not be considered for the purpose of provincialization of services of any teacher and tutor as the case may be of the institution.
Now, what is the relief we are praying for in this?
My lord. That is, your lordship will find at page 21, lordship. Start from 20.
The relief is page 21.
My lord, 20. First prayer. No, lordship, in
You are in which, you are arguing which case? Item number?
2,
And what is the case number?
lordship 141.
What is the matter, Mr.? You don't even know.
But in item 2, item number 2, well, to give you apologization letter, that's the coming minute.
When it was called, you did not appear.
No, well, just I have coming minute.
Why?
But I
You
will,
were sitting here, you didn't appear.
small, but I'm not hearing.
You
Item
are not
2,
present in the room.
I'm item 2, well.
No, we have not understood. Your matter is called up, you don't appear. Somebody else's matter is called up, then you appear.
Malad, I'm not hard malad 2, malad.
You are not?
I'm not hard malad that my item is 2, my calling. Malad.
So you are in item 2.
Yes.
You argue item 2.
Malad. In this case, malad, we have also challenged the section 3(1) proviso, malad.
What is the relief you are claiming in this writ petition?
My lord?
What is the relief you are praying for?
Malad, we have challenged the section 3(1) proviso, malad.
Achha, who is the petitioner?
Petitioners are the head teacher of the respective ME schools, malad. Bhansar ME schools.
Right.
And they have already earlier occasion, malad, they have, as per the advertisement issued by the Director of Elementary Education Assam, they have applied for their provincialization of their schools, malad. And accordingly, they have submitted, malad, as per the 2011 Act. And thereafter, their case has been recommended to the government. And in the meanwhile, some of the person's case has already been considered. But due to the ordinance issued by the Government of India, malad, due to the MP election, their case has not been considered. Though they have been, and their names have been forwarded to the Government of Assam. Then 2011 Act was struck down, malad. And thereafter, the 2017 Act has come up
2011 Act has been struck down by the single judge.
by the division bench, yes.
Any appeal preferred against?
Then the review petition has been filed, malad.
Yes.
In the review petition, malad, it has clarified the persons who have already been provincialized pursuant to the 2011 Act, though their qualification is not enough as per the 2011 Act, their case can be care of, and they are allowed to continue in the provincialization process. But as section 24, as per section 24, malad, the review has to be done by the government or state government, my lord, regarding their qualification and others qualification. But till that, nothing has been done. But in the present case, my lord, they are also similar situated persons, my lord. But their case has not been considered now because of the proviso of the 2000, section 311, my lord.
Let us see the proviso.
Act, new act, my lord. Section 311 proviso, my lord, provided further that the order for such permission, recognition and concurrence shall have to be issued on or before 1/1/2006, and any order issued thereafter with any retrospective effect shall not be considered for the purpose of provincialization of services of any teachers and tutors as the case may be of the institution. But here in this case, what had happened, my lord, the case of the petitioners have already been forwarded earlier, but due to ban imposed by the government of Assam from 1993 to 2005, my lord, no recognition, no permission has been done by the state government. Well, thereafter, in the 2005, the process was started. And due to the huge schools has already been forwarded to the Director of Elementary Education, well, they have
So what is
recognized.
the common question involved in all these cases? Why these have been clubbed together?
Yes, well,
It's a
common
common-
question, my lord.
Why these cases have been clubbed together? What is
My
the
lord,
common?
different provisions of the act are challenged, my lord.
Hmm.
In first item number 2 my lord, 13, 12, provision of section 311 is under challenge, my lord. Then, my lord, in item 13, 14, 15, challenge is made to the section 2Z, 2X, 2U, 311, and 6 and 7 of the act. So different provisions of the act are challenged under indifferent reputation, my lord. That is why all are clubbed together.
What is the ground of challenge?
Now, in 3-1, my lord, they are challenging the cutoff date of 1/1/2006
No,
and
That-
prospective operation of
That
cutoff date.
they are challenging, but what is the ground? Challenging a statute, the law is very well set.
They are saying that they have applied earlier point of time, but their cases are not considered within the time, and they have been given the recognition after 1/1/2006, though their applications are pending, my lord. That is their basic ground.
But they had applied under the 2011 Act.
Not, my lord. Regarding recognition, they have earlier applied, my lord.
Hmm.
And 2011 also the cutoff date was 1/1/2006. In 2017 also cutoff date is 1/1/2006. Their cases that they have applied prior to 1/1/2006, but their cases are considered later on by the authority, my lord. That is why the recognition was granted later on after 1/1/2006. But by this provision, my lord, retrospective, they cannot, their recognition cannot be granted retrospectively, my lord. So that provision is under challenge.
basically, my lord, in this case, we have not challenged the cutoff date 1/1/2006.
Hmm.
But basically, we have challenged that they have by this proviso, my lord, the retrospective effect which has given by the state of Assam, my lord, that has been not accepted, my lord. That is the only provision, problems, my lord. And all the orders has been issued, my lord, slightly different from 1/1/2006, my lord. But given the effect in 1/1/2006 or before that. And in fact, my lord, in the act, in the definition 2ZA, there is no such proviso, only the cutoff date of 1/1/2006. But in the section 311, the proviso extra has been given. That is the contradiction in between the definition of the Vansar schools. Only the problems for the date of issuance of the order. Order has been issued after 1/1/2006 by giving the retrospective effect, my lord. That is the only issue.
Hmm. All right. So that's your case.
Yes, my lord.
And where is the order, impugned order?
My lord.
Is there any order impugned in this case?
No, no.
Only statute.
Only the statute, my lord.
So therefore, on what ground you are challenging this proviso, this rule 3.1?
My lord, basic ground is there is a discrimination in between the same class of persons, my lord.
Hmm.
Because the earlier we have applied in 2011 Act, all the persons have been applied. And some of the persons similar situated already has been provincialized
Hmm.
pursuant to the 2011 Act, my lord. And our case has also been, I have given the documents, my lord. Our case also have been forwarded to the government of Assam. And then government of Assam forwarded it to the finance department. In the meanwhile, my lord, the ordinance has been issued. And due to the issuance of the ordinance, my lord, our case,
Which ordinance?
my lord, the MP election in 2014.
Ordinance or notification? You understand what is the ordinance?
No, my lord, ordinance issued for the election of MP election of 2014, my lord, our case has not been considered. Pending there.
That is not ordinance. What is an ordinance?
Notification, my lord. MP election notification.
Notification, ordinance, everything is same.
No.
Huh?
Sir.
Good, good. So you mean to say the election model code of conduct came into?
Model code of conduct has been imposed,
Huh.
and due to that, my lord, our case has not been considered. And then the 2011 Act has struck down in the meanwhile in 2016.
All right, so item 2 to 12, this is the issue.
Yes.
Yes, my lord.
All right. So what do you have to submit? Anything you want to submit?
My lord, I have already given the written arguments, my lord, already submitted.
So nothing oral.
Yes.
No oral argument. No bad one.
But this is my basic case that discrimination has been.
We
And,
cannot.
and one thing, my lord,
we'll go
I
by
like to
what you-
I like to point out, my lord, in section 2ZA
Hmm.
of the Act, my lord,
Yes, let us see. Section 2Z.
2ZA. Here is the definition, my lord, the Vensar ME schools,
Yes.
page 106, my lord.
Yes.
Vensar ME school, including the Vensar ME Madrasa, means an upper primary school imparting education from class 6 up to class 8 and established by the people of the locality prior to 1/1/2006, which has received recognition from the competent authority on or before 1/1/2006 and captured in the Dice Code up to 2009-2010, and whereof the services of the teachers have not been provincialized under any act enacted by the state legislature so far, provided that the Dice Code shall have to be issued on or before 2009-10 and Dice Code issued thereafter shall not be considered for the purpose of provincialization of services of any employee of the institution. But in 2001, my lord, this proviso has been given extra the provided further that the order for such permission, recognition and concurrence,
Where are you reading? Where are you
my
reading?
lord, the 311 proviso, page 108, my lord.
Yes.
But provided further that the order for such permission, recognition and concurrence shall have to be issued on or before 1/1/2006, and any order issued thereafter with any retrospective effect shall not be considered for the purpose of provincialization of services of any teacher and tutor as the case may be of the institution. But as
So
per the
you
definition,
say
all,
that there is a repugnancy between the
yes,
definition and the.
yes, my lord. Because all the criteria which has been given in 2ZA, we have fulfilled. But only this person, my lord, this portion, my lord, shall not be considered for the purpose retrospective effect. So repugnancy in between the definition of the Venture
Alright,
ME
alright.
schools
Then what
and
is the
this.
next round?
And then in case, my lord, some of the schools, already permission has been granted in 1988, 89, 92, 91, 93, and forwarded to the government of Assam for recognition. But recognition has been done in 2006 with retrospective effect. Slightly, the order has been issued after 1/1/2006 by giving the retrospective effect. So in fact, my lord, they cannot say that our school has been got permission in 2006 only. And my lord, kindly just peruse page 30. Well, kindly peruse the page 30 of my petition, my lord. I have annexed some permission order given to some of the schools in 1991, 1992, 1994.
All right. Who is appearing for the department? Mr. Majumdar, you are appearing for.
Otherwise,
We may not conclude the hearings today, but
Madam-
what is the preliminary response to what he said?
when they filed the writ petition, at that point of time, they had challenged the provisions of Rule 3.1. The section has undergone an amendment after that. We brought it on record also. The amended section has not been challenged. Although the changes are minor, but the wordings of the sections have changed. There is no fresh challenge to the fresh section that has been incorporated. That is the first portion.
What is the amendment?
My lord, we have introduced a certain part.
What is the amendment?
My lord, the middle part of Lordship has the book, Lordship will find, provided that the permission for the first year clauses, first year HS clauses in respect of higher secondary school, concurrence for the first year HS clauses in respect of senior secondary school, recognition from Board of Secondary Education for class 9 in respect of high school, concurrence of TDC part 1 in respect of degree college received from the government, on or before man shall be treated as permission, concurrence, recognition as the case may be for the purpose of provincial exam services, teachers and tutors under this act. This entire proviso was introduced.
So they are saying that they applied before 1/1/2006.
Could be, my lord.
If it took time for the authorities to process it,
My lord.
how can that be a ground to?
No, my lord, here the recognition or the permission, the reports from the SEBA and everything are also to be required. It comes from there also, it comes from our end also. There are inspections to be carried out. If they apply today, it would not mean that they would have a recognition day after tomorrow or on any other day. Merely an application for a recognition would not mean that it would be a recognized school if it is issued on a later date. Recognition would be issued only after the verification of the school from a prospective effect that it
Please
complies with
understand, we are not on the process.
My lord, yes.
We are, this provisions of statute are challenged. There are very well laid down parameters on
3 or
which.
4 parameters on which they can challenge me.
So what he is saying that
My lord.
this is discriminatory. This needs to, listen. You
I'm
come
sorry.
back with your answers because otherwise you will find your answer after the judgment is delivered. Choice is yours. These are not rocket science. It takes 10 minutes to understand what is happening.
Mhm.
The point is there was a statute which has been struck down by the court and that aspect of the matter is closed now. Under this statute, there was provision for applying for provincialization of services of the teachers.
My lord.
The petitioner's case is that many of them have applied long back, at least prior to 1/1/2006. And these applications were pending consideration before the appropriate authority.
My lord.
Subsequently, some of them were granted and some of them are still under process, is it? Some of them are granted with retrospective effect. Retrospective effect from the date of the application.
Yes.
So this is because some time was consumed in processing it. So once the recognition is granted, it creates a right. It confers a right. How can you take away that right by amending, by inserting a proviso in a statute?
My lord.
If the earlier process was as per the provisions of the statute, this is number one. Number two, as he has pointed out, one, what is it? ZA.
2ZA.
2ZA. 2ZA, you are recognizing till 2009. So is there not apparent
2000
contradiction?
I'll answer that.
Yes. So institutions which are established prior to 1/1/2009, they will get. But
2006.
people whose recognition was granted with retrospective effect, who have applied before 1/16, they will not get. What is the design
My
here?
lord, What,
There's
when I,
some design which is
I-
apparent.
my lord, when we had the Act of 2011,
Hmm.
several applications and come in for the provincialization. We took out the entire chart. What we found was the system of granting a recognition is after the permission. In our affidavit in opposition, we have pointed out several instances of the petitioners also, where the recognition has come prior to the permission. So there was a finding of the department that these recognitions and permissions were not granted on the basis of merit, but was being granted to facilitate the provincialization of institutions which were perhaps not entitled to get them. When all this was taken into account, what we found was that 1/1/2006 was a cutoff date, where people where institutions were being granted backdated recognitions or backdated permissions. A school cannot be actually
No,
established
backdated or retrospective effect?
retrospective.
Retrospective.
In some cases, it was
Backdated
backdated.
is something else.
In some cases, they were backdated orders also. We found it, madam. It was a fact-finding issue. Therefore, in this act, what we had given a cutoff date, Lordship will find two things. There is an Regulation Act of 2006, non-government regulations, management of schools. Now, that was a concept of 2006. So 2006 was initially taken off as a cutoff date. That whatever happened before 2006, we'll try to provincialize. Now, when we found out that 1/1/2006 was a date, which after that there were manipulations were taking on. So therefore, whatever was actually true before 1/1/2006 is what we tried to take into consideration. What was given a retrospective effect, or where we found that they were backdated things, those we wanted to exclude at this point of time. And therefore, 1/1/2006 was the cutoff date where we wanted to say that if you got it prior to that, it was okay. We'll take it into consideration. But if it is given a retrospective effect because trying to bring you into that cutoff date of 1/1/2006, then it is wrong. Lordship will find in the earlier act also 1/1/2006, we did not put in any cutoff that it should not be retrospective. 2011, we found there were hundreds of recognition orders.
If people have applied after 1/16,
They have
then
not given the dates of their applications anyway. It is just their statements on record. And Madam Lordship, when I say that the process is of permission and then recognition coming prior to permission in their cases itself shows
No,
That
but
there were manipulations.
your provision deals with something else. It says any order issued thereafter
Exactly,
with retrospective effect.
my lord.
It doesn't deal with applications made after 116.
No, it says that when an
It also
order
deals with applications made maybe in 2000.
1998 or maybe
Yeah.
prior to that.
Only
But
thing is, it cannot be granted
so, my
retrospectively.
lord, in the absence of them asserting that this is my application, this was the date of my application, number one, we are not in a position to verify, my lord. There are around 7,000, 8,000 schools. We don't have the
You
particular.
considered we can deliver the judgment
The-
today itself. That is on facts.
My lord, another lordship will kindly appreciate.
That you verify as per the rules.
That is one part. Second part, lordship will kindly appreciate when the permission has to be to start a school, and then with the permission, when the school starts, they make an application for recognition and they get a recognition. I'm not on the dates, my lord. I'm just on the process that there is a permission and there is a recognition. The recognition has to follow permission. Their own documents show that the orders of recognition are purportedly
These are not arguments, I'm sorry to say. These are not arguments in advance in a proceeding where a statute is under
I
challenge.
understand, my lord.
You are arguing on a merit of a particular claim. We are not considering the merit of any particular claim. The issue before the court is of parity, one of parity. Because parity is a facet of Article 14. When 5 institutions are there, all of them have applied prior to 1/1/2006, but for some fortuitous circumstances, few have been granted before 1/1/2006, and few have been granted after 1/1/2006, but with retrospective effect. This is a usual practice in the government departments. Many times, rights are recognized with retrospective effect. But then it relates to the date, original date, which has to be date of application. What do you mean by retrospective effect? It will take effect from an anterior date. So what is that date?
Lordship will find that in this.
What is that date here? Please listen to the question. What is the date? When you say retrospective effect, it has to apply in retroactivity with reference to a date.
Date.
So what is that date here?
1/1/2006, my lord. Most of the orders are made effective from 1/1/2006, the recognition orders. That retrospectivity date.
Why
which they have-
1/1/2006?
But they have got those certificates showing 1/1/2006 because the act demands that it should be 1/1/2006.
No, but then-
2011 act says.
in
And then
other-
that is where we realized that this is,
But what about the, recognitions granted in case of applicants prior to 1/1/6? That was with effect from which date?
my lord, from the date of the recognition, from the date of the orders, my lord. Those petitioners are here, from those who have got a recognition order in their name for whatever date, issued prior to 1/1/2006, they are not in trouble.
But are you saying that they have applied after 1/1/2006?
My lord, that we could not verify each and every individual case before the act was promulgated. That is true. But what we have found is attempts have been made all throughout to have the orders issued retrospectively, giving them effect from 1/1/2006 because of the order of
You
1.
Sort it out, it
1/1/2011.
takes 2 weeks. You say that all applicants prior to 1/1/2006 will only be eligible. That's all.
But even if.
Why are you saying retrospective effect? That creates a completely different.
But
situation.
the orders which they have come up with is a retrospective effect order.
This is. Pending.
When they claim that the applications are made in 1997 or 1998, the recognition orders are giving them a date of 1/1/2006, the retrospectivity issued in February, giving them an effect from 1/1/06.
You're actually putting the cart before the horse
Yes.
and taking a course which will maybe compel the court to interfere in the matter. You could have very well said that any application made after 1/1/2006 would be treated as null and void. Then we understand that you are introducing a cutoff date. But you are saying even if the application is made prior to 1/1/2006, and for whatever reason there was delay in processing, still it is gone. That would violate the rule of parity. Therefore, will be in the teeth of Article 14. What option are you leaving the courts with?
My lord,
What option are you leaving the courts with?
but since it's a challenge to.
Five person makes an application
My lord,
before us, seeking similar relief. We grant one or two of them immediately and others we say that we are examining it. Later on, we find that it was correct. So we grant it.
All of them.
How can you say that because if it is took some time in processing, therefore your right is wiped out? That kind of argument will be very difficult for the courts to accept. You must apply your mind on that.
I'll
That's all we are saying.
let this.
All right, you make your submission, we'll pass our judgment, that's okay. But that should not be the approach. On the face of the record, you are violating the rule of parity. That's what we find. Because if they have applied after 1/1/2006, you are at liberty to throw it out. The statute permit. But for those who applied prior to 1/1/2006, some have been granted, some have not been granted before that date, but was granted later on. How can you distinguish these two categories? This is discrimination. On the face of the record, this is discrimination. And by a statute, you want to wipe out all the applications and completely annihilate the rights of this category.
My lord,
And you expect the court to say that this is in accordance with the constitutional principles. Very, very difficult, Mr. Mathur.
understand, my lord.
Very, very.
Lordship will keep
You
that
get
as a.
one more chance.
My lord, Lordship will keep it as a tentative view, my lord, today, because it's a challenge to a rule, my lord, the learned AG also perhaps has to address. I will apprise him of
That
the,
is for this
of the
state.
view of this honorable court, my lord. Will come
Yeah,
back, my lord,
state
one
is
step.
free to engage the AG or you.
My lord.
They are not on that.
My lord.
But this is the tentative view of the court,
Yeah.
unless you can meet this argument.
I'll try to address it.
What we are saying is to meet with specific situations. Instead of verifying each and every application, let's pass a statute wiping it off. That appears to be the idea. But that idea on the touchstone of constitutional morality will be difficult.
I'll try to build my arguments on.
What is the second category of case? 13(2). Item 13(2).
One.
2J, 2X, 2U. 13 to 17, who is it?
Lordship, especially the lordship, one thing is, in secondary school lordship, it is some difference from a ME school lordship, in middle school. Question is that lordship,
You are in item number?
item number 10 lordship. Page 56 lordship.
Yes.
Page 56. It is a notification lordship from Government of India and it is passed by the Governor lordship. Question is
Government of
that
India
the
passed by
Governor of
Governor.
Assam, the Governor of Assam is placed a notify the information of 8 years education cycle of elementary stage and consequently class 8 in secondary stage and class 5 in upper primary stage of elementary education shall be integrated with upper primary and urban. So lordship, in
There is
our
no-
cases,
Listen, there is no challenge to the provision of this.
no, lordship, I
statute.
also just coming, lordship.
Please answer the question of the court first, otherwise we will not hear you. Is there any challenge to a statutory provision in your case?
Lordship,
Which provision?
311, lordship. Cut-off period, lordship, 116.
So that he has already.
Now
done.
question is that lordship, our base year is class 8 lordship. But after 2010, our base year is class 9 lordship.
I will- Yes, item 13, call up. Item 13.
Please, your lordships. Your Lordship, in this matter, senior counsel Mr. Deedas appears, he is out of station. If it is
You argue, please. Tell us the basic facts. What is the challenge here?
Your Lordship, the virus of the act has been challenged.
Which act, which provision? Yes, what is the relief portion, please?
Your Lordship, the Assam Education Provincialization of Services Act 2011.
Hmm. So can you please tell us which are the provisions you are challenging?
Your Lordship, section 2J,
Hmm.
2I,
Hmm.
2X, 2U, 3(1), subsection 1, 6 and 7 of the act.
Why it has been challenged? What is wrong with you, Jay? What is wrong with 2J?
Your Lordship, I'm not prepared.
Why you are not prepared? You are a lawyer, is it not?
Yes, Your Lordship.
Then- Or you don't want to be recognized as a lawyer?
No, Your Lordships, I want to.
Then you
Yes.
tell us. You are appearing in the case, tell us. What is wrong with 2J? So what is your name?
Lordship,
What is your name?
Lordships, S. Sharma.
S.
S. Sharma.
S. Sharma. We are asking you a simple question. You have the brief, right?
Yes, Your Lordship.
We are asking you, what is the provision of the statute that is under challenge here and what is wrong with this? That's all. According to you, what is wrong in you are the counsel appearing in the matter. You can't say. Has anybody asked you not to read the brief? No. Has your senior asked you not to read the brief?
Your Lordships, no, he did not say that.
Then, are you feeling proud about your stance today? All right, your future is in your hand. We'll do our job. Yes, anybody else in item 13? Item 14, anybody else? Just wanted to know what is the matter about.
Yes, my lord. In this matter also, my lord, 311 challenges, my lord, and 2Q, 2X, and 2U, my lord. 311 in cut-off date 2006, my lord. My similar situated person already provincialized, my lord, but we are late, my lord. Same qualification, same, my lord. Before 2006, my lord, we have
Are you also
recognized.
challenging 2?
3-1, yes, my lord. Page 38, my lord, kindly.
Are you challenging 2J?
Not in this case. 2Q, 2X, 2U. This 14.
You have not challenged two X.
Yes, my lord, two excellences.
Why are you challenging two X?
Yes, my lord, page 38 I have mentioned, my lord,
Yes.
page 38, para 28, my lord.
Yes, what is the ground of challenge of two X?
Yes, my lord. Basically to provincialize the service of teachers and tutors of the Fensar education institution in the state of Assam to restrict further establishment of such institution. As per the definition of Fensar High School as provided in section 2X of the Act 2017, it means the high school imparting education up to class 10 and established by the people of the locality priority to 1/1/2006, which has received permission from the state government and recognition from the Board of Secondary Education, Assam, on or before 1/1/2006, and whereof the services of the teachers have not been provincialized under any act enacted by the state legislature so far. The petitioner state that the same definition
Oh,
also.
wait a minute, why are you challenging section two X? Tell us that.
Yes, my lord.
Why? What is wrong with it?
My lord, before my lord 2006, my lord, we have recognized, my lord.
It only says senior secondary school means junior colleges imparting education up to class 12. Prior to that particular, within that purview of that particular act. What is wrong with it?
Yes, my lord. Here, my lord, next page, my lord. But surprisingly, the Act 2017 has introduced a new provision to the section 311.
We have
Which-
seen that. What is the ground of challenge of this provision? We are telling you.
Yes.
Please respond to that. Why have you challenged this?
My lord, some discriminatory,
Huh?
my lord, in 2017, my
Some
lord.
discriminatory. What discriminatory?
Yes, my lord. Here, my lord, cut-off date has been given, my lord, my lord.
What is the cut of?
Yes, my lord. Therefore, page 39, my lord.
Hmm.
Therefore, the petitioner state that the high schools and service of the petitioner should
So
not
you
be.
don't know what is your case. You are
Yes,
going to
sir.
just read the
Yes,
statements here. Well, then please step aside. We are not interested. Anybody else who wants to argue in item 13 to? Item 13 to 17, anybody else wants to address the court? All right, then this group also.
17
What is
also
the-
same, my lord.
Huh?
17 also same, my lord.
Next. 18 to? 18 to 20?
My lord, 18 and 19.
Yes. What is the issue here?
Sir, here. My lord, we are here challenge the validity of section 2J, 2X, 2U, provision to section 3(1) subsection 167.
So why are you challenging 2J? On what ground? Yes, why are you challenging 2J?
My lord,
You don't know. Why are you asking him?
no, my lord.
Huh?
18. It up to.
We are asking you, mister, why are you challenging
My lord,
section 2J? You want it to be struck down, why?
the petitioners are teachers of lower primary schools, and they have been recognized and established their school before 2006, and they have got recognition, but their service was not provincialized under this new Act 2017.
So we are asking you, why have you challenged 2J? You can't tell us, then we'll dismiss it right now. We'll dismiss your petition. You are not being able to say why you have challenged 2J. Want it to be dismissed?
Actually, my lord, my senior Honorable Diganta sir is out of station. He is
Maybe we are, see, let's make these things very clear. We respect seniors' assistance, but no matter will be adjourned only because senior is not available. Absolutely be clear about it. Whatever it takes, it takes. We are sitting here to do our job, we will do our job. The fact that a senior is present or absent, or somebody is here or there, that cannot compel us to rise from the court. Don't make this request, we will not accept it. Will not accept it. So please argue your case. Seniors are most revered. We appreciate their contribution, their presence is important, but they may have personal difficulties. That cannot be overriding the court's duty to do its job. Seniors are there, we welcome, not there, we'll proceed with the matter. If we feel that we need to wait for a senior, that's what we will decide. You can't ask for it as a matter of right. That senior is not there, senior has gone for a holiday or somewhere, so you please don't work. You can't say that to the bench. Please address the court and we'll decide your case just now. Today we have this division bench only. We can't rise like this at 11:30. All right. So you don't have a case. Next man. Anybody else?
Item number 20, madam.
Yes.
Yes, madam. Here the challenge is, my lord, section 2ZB of the Act of the 2017, madam.
Yes, which item? You are in which?
Item number 20, madam.
Yes. Item number 21.
20.
You have challenged section 2ZB.
Yes, lordship.
Why?
Because, my lord, there was a, my lord, date given for the dice, madam. 2000, it is a date which was given 2009-10. But my case is that, my lord, though we have, my lord, established in before 1/1/2006, but the dice code which was, my lord, given to us, my lord, 2014 and 15, my lord. And we have submitted, my lord, the representation before the authority also, my lord. But they have not corrected this. My lord, but I find, my lord, in earlier
What is the provision of this statute under challenge in this case?
2ZB,
Why are you challenging?
because this is the date given, my lord. Lordship may kindly see. I am allowed to read, my lord.
Yes, why? What is ZB? Please read it.
My lord, venture lower primary schools or venture LP school means a school imparting education up to class 5 and established by the people of the locality prior to 1/1/2006, whose name figure in the dice code up to 2009-10. And prior to that, and whereof the service of the teacher have not been provincialized under any act enacted by the state legislature, so provided that the dice code shall have to be issued on or before 2009-10 and dice code issued thereafter shall not be considered for the purpose of provincialization of service of the any employee of the institution. My lord. So, my lord, my case is that my school was established prior to 1/1/2006. Thereafter, it is continued, my lord. But dice code, which was, my lord, given to me.
So what is wrong with this? They have
My lord.
put a cutoff date. Your
Yes, my
school
lord.
is not prior to 1/1/2006.
My lord.
Then what is wrong with this? Why are you challenging it?
Because, my lord, since the earlier act, my lord, there was similar provision in the earlier act also, my lord, I have gone through, my lord. But since earlier act is not, my lord, in exist, my lord, so my grievance, my lord, so far my grievance with regard, my lord, and in 2017 act also, my lord, has not given any, my lord, purpose. And as per
They have
section
not
20,
given any?
my lord, any provision, my lord, what will be the, my lord, act of impact of the earlier act, my lord? And section 24, my
So
lord.
you want the court to insert a provision into the statute?
No, my lord, I have submitted a representation, my lord, before that. That time also, my lord. And they may be considered, my lord, on the basis of the representation, my lord, by the
Your school is not established prior to 1/1/2006.
established prior to 1/1/2006, my lord. But dice code, my lord, only problem with the, my lord, dice code, my lord.
Why did you not get your DICE data before 2009-10?
My lord, I approached the authority, my lord, they have not corrected, my lord. I will make a statement, my lord.
Then you should have come to the court. You did not get a result doesn't mean a statute is bad.
Oh, sir.
That cannot be a ground.
This is my lord.
So we'll dismiss it, but not today. Yes, next matter. Next category, please.
Yes, 20.
Yes. Can you add anything to what has been already argued?
Lordship, here we have challenged 2J, the definition of employee, which says that any person who is employed before 31/12/2010 would be eligible for provincialization. I was appointed by the school management committee in 2011. Therefore, I do not come in the definition of employee. Therefore, my services has not been provincialized. Now I have challenged this provision firstly because the date has no reasonable nexus to the object sought to achieve. The object of the 2017 Act was to first to reorganize the schools in such a manner so that it fulfills the statutory norms, firstly. Secondly, not to further add to the existing schools, therefore the date was given. Now, the statutory norms is given in the RT Act and the rules. Now the RT Act and the rule says that there has to be a teacher for every subject. So if this date is implemented, then there would not be any teacher for the languages, in my case. So if it is implemented, then it will be violative of the Central Act. And it will have no reasonable nexus with the object sought to achieve.
No, but how can that be a ground to strike down a statute?
Yes, Lordship, the statute primarily can be struck down if it is violative of a Central Act or it's violative of the fundamental rights. Lordship, the date firstly creates an classification within a class. So the date, the distinction made by the date has no reasonable nexus with the objects sought to be achieved, firstly. Secondly, if this date is implemented, then it will be violative of the Central Act. So the Central Act is made under
Which Central Act? Let us see.
RT Act 2009.
Yes, where is it? Have you got it?
Yes. Yes, firstly, Lordship, I'll read out.
Have you, is the act annexed to the writ petition?
Lordship, in another petition, I have annexed, but this act, it will be found in the earlier book, brown book. In this green book, it doesn't contain the act.
RTA Act is here.
RT Act khona se likhe.
Just make a note of list of books. Which date?
Lordship, I can slowly read it out. No school shall be established or recognized under Section 18 unless it fulfills the norms and standards specified in the schedule. Where a school established before the commencement of this act does not fulfill the norms and standards specified in the schedule, it shall take steps to fulfill such norms and standards of its own expenses and a period of 3 years. Now, this section says that if a school does not fulfill the standards and norms prescribed in the schedule, they are recognized, will be cancelled. Section 18 also says that, Lordship. Section 18 says no school to be established without obtaining
Right to Education
Act. Lordship, the schedule.
But this is too omnibus a ground. There is no, the Central Act does not at all.
Lordship, I'll read out the schedule, Lordship. The schedule has what is the standards and norms is given in the schedule of the RTA. One of the, firstly, at least from at least one teacher per class, so that there shall be one teacher each for science and mathematics, social studies, 3 languages.
So the consequences of implementing a particular statute, according to you, would result into a situation where there will be no teacher in the language department.
Languages. And
so the
there
statute is bad.
Yes, Lordship, because it will be violative.
This is on the next date. Yes, next matter. You don't have a case. There is no such. You can't challenge the statute on this grounds. If there is anything you want to add, come prepared. So far, what you have argued, it is a straightforward case of dismissal. Yes.
Deeply.
Any other category? Anybody wants to argue anything?
Item number 15, your Lordship, we have telling the cutoff date of 1/1/2006, Your Lordship. Our schools are, Your Lordship, established in 1988 and 1995. But Your Lordship, because of the ban by the SEBA, Your Lordship, we could not file applications. Subsequently filed and granted
the permission was granted with effect from
But your school was prior to 1/1/2006.
2006.
Your application was also prior to
Lordship.
1/1/6.
That's it. And in view of that, your lordship, we say that this particular cutoff date is unreasonable, manifestly unreasonable. This was case so far as
We'll-
item number
We'll we'll close it on the next date because some requests have come.
lordship.
But next date, there will be no adjournment.
Lordship, we have some judgment also, your lordship, we will rely on that, your lordship. And there is another matter, your lordship, 50, your lordship. Item number 50, your lordship. Here, your lordship, the government has not
No,
filed.
Wait, we'll come to item. 50.
Lords.
This is which item? Yes, anybody is appearing for 23, item 23?
My lord, 23. My lord, in this act, in this case, my lord, several section has been silenced. One of the section 2U of the Act 2017, here the petitioners are the teachers of junior college, that is senior secondary school, but they are appointed as tutor and they have challenged it because, my lord, in section 2U in the Act 2007, it creates a new category of teachers, teaching staff, namely the
Why
tutors.
have you challenged section 6 and 7 of the Act and 24?
That, my
Why have you
lord,
challenged section 6?
by virtue of section 6 of the Act 2007, the state government of Assam has changed the required qualification criteria for the teachers, lecturers in the franchise educational institution from the criteria prevailed under the earlier law, including Act 2011, section 6 of the Act 2017 reads as follows: the service of teachers in a venture educational institution from the primary level up to the degree level shall be considered for provincialization in the post of teachers or relevant teaching faculty in appropriate nomenclature, as the case may be, subject to fulfillment of eligibility criteria relating to educational and professional qualification as laid down under the following acts, rules, and regulations. My lord, that the petitioner stated that the aforesaid provision has introduced eligibility criteria for teachers working in various venture educational institutions whose services would be provincial. The petitioner stated that section 6(2) debars every teachers working in the venture
All
educational.
right, you are not prepared. Yes, move on. Next. Item 25 to 47, anybody is there? You're challenging 3-1-11, is it?
No, my lord. 3-1-10, my lord, actually, my lord. Because it's shown wrongly, my lord. 3-1-10, my lord.
3-1-10.
Yes, my lord. Item number 25.
3-1-10, yes.
10, my lord. Other case 3-1-11, but my case 3-1-10, my lord.
Yes.
Here, my lord, restricted it to, my lord. Only 2 teachers will be provincialized, my lord. Just restriction we have challenged, my lord. We are 3rd teacher, my lord.
So in the earlier act also, there were 2 teachers. There was
That was one of the ground, my lord. Earlier act was, my lord, nullified, my lord, declared void, my lord. That was one of the ground in the earlier judgment, my lord. Restriction of 2 teachers, my lord. And that is violation of, my lord, RTE Act, my lord.
No, but the government will have to look at their own resources. If there are 20 teachers, all of them have to be provincialized.
No, suppose 3 teachers appointed, my lord, in the same year, my lord. Suppose 2 teachers appointed 1 month back, my lord.
No, but can the court demand that all of them will have to be regularized, whoever is appointed whenever?
This is RTE Act says, my lord, according to students, my lord. Suppose student is above 60, my lord, then
Right.
it will be
Anything
3
else?
teachers, my lord.
Anything else on this? Any
Submit
other-
on the next date, my lord.
That's not a ground to challenge, strike down a statute.
Earlier judgment also, my lord, referred this point, my lord.
Hmm.
Restriction of 2 teachers, this is, my lord, illegal because, my lord, RTX says if a student is above 60, my lord, then 3 teachers, man. So we are
according to
applying
you,
1/2011.
the Act of 2017 is contrary to the judgment of the division bench earlier.
To that effect, my lord.
That we'll have to examine.
Yes, ma'am.
All right. Anything else?
Abulash, ma'am.
Any other new angle? Any other new? provision?
I'm for 3111, my lord.
Hmm.
3111, Lord, in this case, my lord, there is a notification, my lord. And the division bench already, my lord, just struck down that, declared that unconstitutional that 2011 Act. So, my lord, at the time, my lord, there are just 6 teachers, my lord, in the for recognition, my lord, it is necessary 6 teachers having, my lord. But 2017, it is restricted to only 3 teachers, my lord. We are agree on that, my lord.
কেটে আমি এই মেটাকে কেটে দিই। কেটে? I don't know.
So in item number 52, lots of notice is yet to be issued. Also here, lots of after serving for long 13 to 14 years, and after 3 rounds of verification process, lots of our services were provincialized. Now, lots of by an MP order, lots of our salary has been stopped for the last 1.5 years. Now, in this writ petition, lots of we have challenged the virus of Rule 3232, lots of, at page 69 of my writ petition, lots of, wherein it says, lots of, in case of Venture Degree College and a Venture Secondary School or Venture High School, the eligibility criteria specified in subsection 1 above regarding date of recognition, affiliation or concurrence, minimum enrollment and performance would mean in respect of each of the subject. I am challenging this in respect of each of the subject because our schools were given recognition, permission and acquirance lawsuit prior to 1/1/2006. Only because of this lawsuit in respect of each of the subjects, although lawsuit the departmental communications were there prior to 1/1/2016, but subject-wise concurrence was received after 1/1/2006.
All right, so we have got a feel of what are the matters. We are fixing these matters on 19th. In fact, that infrastructure matter was not 18, make it 19th. And we would like to round it off on the next date. So
We will come prepared.
no prayer for adjournment on any ground, particularly senior not available, will be entertained. So anybody who makes this prayer will do it at the risk, at his or her own risk and cost. We will not defer hearings on these grounds. All right, this has come for the first time, we can understand. But next day, there will be no adjournment on these grounds. Let it be known very clearly. You take down.
Also, in my writ petition, notice is yet to be issued also. In this writ petition, notice is yet to be issued. I don't know 52.
We'll pass an order, so it's challenged to statute. Yes, Mr. Das, you are there?
I am there in item number 29, 30 possibly. 29, 30. I have challenged the call 3(1)(11). Section 3(1), clause 11. Only that section. Only 3 teachers are to be permitted. That clause. Huh? No. It is the only dish.
So where does it say only 3 teachers are to be provincialized? Page 111.
In case of Venture Upper Primary School, there shall be minimum 3 teachers or tutors, at least 1 teacher each for science, mathematics, social studies and languages. These clause, they are interpreting, the authorities are interpreting as inducting only 3 teachers. One for science and mathematics, another for social studies, and third for languages. Only 3 teachers can be inducted for provincialization.
But that, if the authorities are wrongly understanding a statute, that cannot be a ground to
No,
strike it down.
That is, your lordship has to clarify whether this is a condition under section 3 for condition for recognition, condition for eligibility, or it is a substantive provision.
If your client is aggrieved because of this and has a right which could have been implemented but for this clause, then we can consider granting individual relief. But how can that be a ground to challenge a provision of the statute?
Now, if this clause is interpreted as one giving only 3 teachers to be provincialized,
Who has interpreted it? Who has interpreted it as only 3 teachers?
therefore interpretation from your lordship is required.
Mr. Das, I am saying this to your juniors, just throwing papers to the court, you interpret, we feel it is that, you go and write your judgment. That attitude for the courts is getting very difficult. There is the ground on which your instructing counsel has prepared this brief appears to be totally misconceived. So we have other things to do. Why should we entertain? This 3(1)(11) does not at all say this. It says only that there must be minimum of 3 teachers.
No, if it is a condition for eligibility, your lordship will see section 3, eligibility criteria for selection of educational institution. That is, the 3 teachers, my concern is that 3 teachers must be there in the school, and then this school will be eligible for provincialization.
But what is the ground for challenging this provision of the statute? That's what we are asking. Statutory provisions can be challenged on very well laid down parameters.
Yes.
Right. Somebody likes it, somebody doesn't like it, somebody find it should be this. These are not grounds. What are the grounds? You know it very well. So I am asking you, on what ground is this provision challenged? We are asking you rather. Because these are serious matters. We are hearing challenge to statute enacted by the state legislative assembly. Serious business.
This is being challenged because subsequently it says the right of children to free and compulsory education act, it should follow.
All right, please examine this.
Yes.
If you feel that this doesn't belong to this category of
Yes,
cases,
yes.
then kindly inform the court. We'll close it by granting liberty to avail appropriate remedy. But
I'll look into it.
please examine.
I
it.
was also thinking of that.
You are also thinking.
Yes.
That's good. The thought process is on the same plane.
Same line.
But we are trying to
Yes.
separate the grains from the chaff. Where there is a real issue, which is a legal issue and deserves consideration of the court, we'll do it. But we have found that a lot of cases are misconceived cases, which are just pending since 5-6 years, where people have just filed it and then decided, first they file and then they see what is the grievance. This is creating problem for the system. Therefore, we have to, today's
Yes.
exercise is to see how many of these are genuine cases.
Yes, yes.
And we have made our notes. But we are requesting you
Yes, yes.
that please examine this aspect of the matter. Maybe you are not briefed on this. So examine it, and if you think that this deserves to be handled in a different way, at a
Yes.
different level, this DB is only for
Only for the provisionalization.
provision of statute. Otherwise, there are other designated
Yes.
benches for this. And we want a little more clarity on the matters So we request you to please examine
Okay.
this.
Your lordship, not today, Paul. Your lordship is granting some time to us.
Yes, yes.
Yes.
We are fixing these matters on 19th of March.
19th of March.
Yes, yes.
Yes. certainly.
Led by Mr. B.C. Das, Lanet Senior Counsel. We have heard the preliminary arguments advanced by some of the learned counsel representing the petitioners in this batch of petitions. However, request for adjournment has been made on behalf of some other councils, primarily on the ground that the engaged senior counsel is unavailable. Full stop. Mr. R. Majumdar, Mr. N.J. Khatuniar, and Ms. P. Das, learned counsel for the
Department of School Education. me and him.
Department of School Education, Mr. Majumdar, Department of School Education, Mr. N.J. Khatuniar, learned standing counsel.
Department of School Education.
আচ্ছা এটা হলে এই দুজন ডিপার্টমেন্ট অফ স্কুল এডুকেশন আর মিস পি দা and standing council SSC are present on behalf of the official respondents. So, taking note of the request made at the bar, these matters, hearing of these matters now stand deferred till 19th of March 2024. Registry to list these cases category wise, again on 19/3/2024 as fixed items. So you are available 19.
Please.
Anybody has any problem with 19th March? All right. So, Mr. Majumdar, this is a serious question. You have to answer the
The
court
retrospectivity, yes.
because we can understand you coming up with a deadline that schools which have not been created or which were not
In
did not
existence.
apply before this date, they would be debarred. But if they have applied, but we took a time, but still,
I like this.
so you are questioning your own activities. You are questioning your own action. That is embarrassing, and if we have to write a full-length judgment, we will deal with this. What are you saying that the retrospective recognition given by the department is bad? So the department is the government. The governments may change their character, color, that is another thing. So you are taking away your action. You're wiping out your action by bringing in statute. How can you do that? When there is an element of accrual of right on some individuals.
Cannot be correct.
They have granted it retrospectively, you have taken it away retrospectively. So if they, what they have done is wrong, then what you have done cannot be adjusted as right.
And
And I am telling you, we could have delivered the judgment today itself if they had not asked for adjournment. It is as open and shut, of course. Now you get the time, you argue. Rest of the case is questionable.
Matter, my lord. Actually, my lord, I'm for the NIT in this matter. Here we have started a recruitment drive under the PM's mission mode of recruitment. And the read petitioner here, they have approached for they are the contractual worker and they want to regularize their work. Since we have started a mission for the recruitment, which is completely different from the issue raised by the petitioner. So now they have started an agitation against us in the institute. We are not able to function in the institute because they are blocking the roads and everything. But though we have given the communication to the district commissioner as well, but till now the condition is not in a stabilized position. So my lord, there is an urgency. Can it be listed on?
The pending matter.
It's a pending matter, my lord. Though actually, my lord, this in this matter, date has been fixed on 29th of this month itself. Since there is an urgency because of this reason, my lord.
No, what is the relief you want here?
My lord, actually, since the petitioner who are actually going for agitation, they are in a confusion that though there is an interim relief provided by this court, they're in a confusion that this two recruitment process, there is same.
But then you have to file an IA. If the matter is fixed on 29th, you can't get it on earlier than that, just like this.
Yes.
You have to file an IA. We'll have the IA listed.
Okay.
File it and come. We'll grant you pay.
Yes. Obligation.
Your lordship.
My lord, I'm praying for listing of an IA in a pending writ petition. My lord, writ petition was challenging an order of compulsory leave.
What is the idea about?
IA now, my lord, is to apprise this honorable court that during the pendency of the writ petition, suspension order has been issued. So, my lord, any day, my lord, convenient to this honorable court next week, perhaps.
Yes.
My lord, may I suggest?
Yes, yes.
My lord, can it be on
Yes, 7th February. Yes, next.
7th February? my lord?
It is a lordship. I beg to mention a matter for motion tomorrow. The reason I'm mentioning it for tomorrow is that a similar matter, your lordship, is placed before your lordship, item number 12. Motion item, your lordship. I'm grateful, your lordship.
Daily list for motion item 1.
Lordship, please. Yes, Mr. Majumdar. What is the instruction?
We have written instruction which basically says that the district and session judge who forwarded two lists, the names of the petitioners do not figure in any of the lists. And we have produced the copies of the lists also.
That's his case. That's what they're saying, that they have not been informed that they have not selected.
My lord, we will proceed according to the list received from the district session judge. Our, my lord, may kindly see, we say that the two lists which were forwarded to us did not contain the list, name of the petitioners. So,
What is his grievance here? What is the?
My grievance is that my name has not been included and the exclusion has not been intimated to me. That's my grievance. Now, the role of the first person is that to collect the documents and forward it to the concerned person. If I don't qualify for whatever reason, then they are supposed to intimate to me. If there's any objection on my behalf, that has to be again dealt by a different procedure where they have to call me. They have to.
So where is the requirement to intimate?
Yes, that I have already quoted in the writ petition, your lordships. The rule. Can I give the copy to him? Copy to him.
Yes.
6.1. Preliminary action on the application. So the application is invited, application is submitted. 6.1. The competent authority shall examine every application received by him, and if he is satisfied that the application is not complete in all respect, or the application does not possess the qualifications specified in Rule 3, or that any application of the applicant for appointment as a notary was rejected within 6 months before the deadline, shall reject it summarily and inform the applicant accordingly. That's where my grievance is. So since there is no intimation from there, I presume that my name should have been there in the list for whatever reason. If it is not, then I am supposed to be intimated. I still don't know.
So, all right, now we'll ask them to file affidavit.
Yes, grateful.
And supposing they intimate now, then what will happen?
The process is now, I think the list is still not out. Interview is now completed, but the result of the list is still not out. So
if you succeed, we'll ask them to interview you and then.
I'll be grateful.
That's all.
There are one thing I have to indicate. Lordship may kindly, Lordship has seen that, Lordship may kindly have a look at page 35 of the application, the notification of 24th of July 2023.
How many notaries are going to be notified now? Is there any fixed number?
Yeah. Our advertisement is 36 numbers of notaries. That's at page 35.
So we'll ask them to go ahead with 34 and keep 2.
Lordship may kindly see one thing. Page 35, Lordship may kindly have a look. This notification is by the district and session judge. And applications has to be made before the district and session judge. Next page, Lordship, he's particulars are there, where is his application? This is what the district session is, we are saying that the two lists we have received from the district session judge did not contain his name. Maybe he had not applied.
So that, therefore, you file affidavit.
Well, we file affidavit. When prima facie, he has not annexed the application which he has filed before the learned district session judge. Lord, may kindly have a
So
look
that
at
means
it.
I'm rejected. That has to be intimated.
No,
That's
man.
my grievance.
When a rejection will come after that.
So that's
First, he has to make an application. If the application itself is not made.
Mr. Phukan, let's be a little pragmatic. You informed that he has been rejected. We'll close this.
No, my lord, if we have not received the application, there is no question of rejection, my lord. Lord, may kindly have a look at page 35 first. Applications are invited by the
Become a RTI application almost.
applications were invited by the learned district session judge by page 35. Now, next page, he gives the form number, but where is his application? And that is why, my lord, may kindly see the instruction. It says,
Form 37 is in fact our
So is
application
there a
also.
statement that your clients had applied, submitted application?
Yes,
he has made a
yes,
statement,
yes.
para 4 at page 11, but he doesn't say who, to whom and when he has made the application.
No, that, okay.
My lord, he has to
I
make
have
the
said that I have
application.
annexed all necessary
No,
documents
no,
also.
he has not made the application before the district. My lord, that's what. Lord, may kindly see his averment in the petition itself.
The
The
Form
petitioner
1.
as being eligible applied. Application has to be made before the decision session judge. And the application he has not annexed and he has given only the form.
So this interview process is now going on or is about to commence before the interview board under the chairmanship of this private respondent, is it? Chairmanship of the respondent number?
We are not against that. That is this other petitions which are pending.
So
I have not
interviews have
challenged.
commenced already?
Yes, interview has commenced. There are different districts. In our districts also it has commenced. I believe the appointments have still not happened, but the interviews are completed as of now. That is what's been
Go
told. to
ahead
me.
with 34 and.
I'll be extremely grateful.
If it is ultimately found that he has not made the application itself, then
So then
because-
that's why we'll fix it.
Rule-
Let it be placed on record by affidavit.
Madam.
And
Rule
then-
4 says he has to make an application. He has said he applied, but there is no application before the
We heard
district.
Mr. R.V. Phukan, counsel for the petitioner. Also heard Mr. D. Majumdar, who has learned in AG Assam appearing for this. Who has obtained instructions in terms of the order dated 12/1/2024. Passed by this court and placed the same for perusal by the court. As per the written instruction dated 1/2/2024.
Second page, second paragraph.
It appears that two lists of candidates were forwarded by district and session judge Kamrup for the purpose of participating in the interview process, but the names of the petitioners are not there in the aforesaid list, in the aforesaid lists, full stop. Mr. Majumdar submits that it is doubtful as to whether the petitioners had at all submitted valid application before the competent authority, full stop.
Only one aspect, my lord. It will be for the lordship may kindly take the response from the district. If they say that they have not received the application, then it's the end of the matter. From district, we'll have to clarify whether they in fact received any application from him.
On the other hand, the grievance of the petitioner is that even assuming that they were not selected or shortlisted by the district judge, the said fact ought to have been informed to them as per the mandate of rules 6 and 7.
Yes.
Of the key rules are select. 6 and 7 of the
Notaries rule.
Notaries Rule 1956. which has not been
1956.
Done in this case. If the petitioners had in fact not submitted their application in the prescribed format before the competent authority, then the question of intimating them as per Rule 6 and 7 may not arise. However, the said aspect of the matter cannot be determined unless an affidavit is filed by the competent authority to that effect. Full stop. On the other hand, it is submitted at the bar that the interview process is underway. And after the completion of the same, uh, appointment of notaries will be notified by the government of Assam. In view of the above, this matter would require further examination. Issue notice of motion returnable on 18th of March. 18th is okay with you? 18th March?
18th,
Or
yes,
you want it 22nd March?
22nd. Let's give it
22nd,
22nd.
22nd March.
This application, your lordship, my learned friend is saying, is actually being countersigned and stamped by the judicial magistrate district.
That's all right.
Case 38. So this is the application which goes there.
22/3/2024. Who's accepting notice for whom? Mr. D. Nath Lanet, Senior Government Advocate Assam has.
One, two,
notice for-
three,
Oh, D.
four,
Madhukar,
one to
assisted
four.
by Mr. Nath.
Four also. 1 to 4 will accept, but register decision session judge,
Mr. Das
standing council high court can.
and Mr. H.K. Das, Lanet Standing Council, Guwahati High Court. Accept notice for respondent number 5. Service of notice is deemed to be complete in this case. Extra copy of the writ petition be furnished to the Department of Council so as to enable them to obtain instruction and file affidavit.
Oh, yeah.
Let this matter be listed again by reflecting the name of Mr. H.K. Das, Lanet SC GHC in the cause list. Heard on the prayer of interim relief. The said prayer will be considered after affidavit is filed by the respondents responding to the claim of the petitioner. However, since the interview process is underway, hence having regard to the facts and circumstances of the case and also balancing equities, as an identity measure, it is hereby provided that on completion of the interview process, the respondents may notify the appointment of 34 notaries by keeping 2 vacancies awaiting further order in the present writ petition.
I'm extremely grateful.
Also may keep a date in the first week of March also. First week also, because now they will have to respond whether they have.
Sure, then you want it earlier?
Yeah, no problem.
Then agree on a date, please.
Man,
Instead of 22nd March, then make it 6th of March then, 6th of March.
6th of March.
6/3.
fifth,
5th is a non-motion day,
then fourth,
4th of March.
4th of March.
A copy of the written instruction dated 1/2/2024 be retained in the record.
Extremely grateful.
For admission, I can do.
The matter regarding selection and appointment of supervisor regular in the social welfare department of differently able persons. In pursuance of this order, honorable court order, I have perused the record of the case and the findings has been brought to the record by filing an additional affidavit. Also may kindly see the findings of the it starts from 105 lots.
Additional affidavit has been filed when?
Is filed on 4/1/2024.
You have received copies, Mr.
Yes, yes.
Just a minute, please take your seat. Come back to you. Was any post reserved for persons with disability? How many posts were to be filled up per basis?
20 posts, my lord. Regular 20 posts.
20 posts.
Lordship.
So 3% of 20 is,
But 3% of 20 is point, we said that 3%, if we go by 3%, it doesn't come, no? It's 0.6.
where is the advertisement notice?
Page
Page number?
29.
Page number
29.
20.
29 in the writ petition, NHF 4. Oh. So page 29, serial number 2, supervisor, temporary post on regular basis, number of vacancy 20.
So no post was reserved for PWD.
Yes.
Then what can be done now?
Lordship, no, the 0.6 means 1. Lordship, there is a,
She, after that, she never applied for any other post.
no.
Why? 2014, after that, there were several advertisement issued. There were posts for a PWD candidate. He did not apply for anyone. Why?
Lordship, there is an indication regarding the reservation of physically handicapped persons in the advertisement also. So, 20 out of 20.
Where is the indication?
That reservation, my lord. That is a mistake on their part, my lord. In fact, the format, in that particular format, they have reservation for SC, STP, STH, OBC, MOBC category candidates as per the statutory provisions made by the government of Assam, including reservation for persons with disabilities as per existing norms. Candidates must enclose the copy of the caste certificate and copy of the disability certificate for disabled persons where applicable. But for this, my lord, reservation rule, in fact, this has been mentioned in all the categories, my lord. But for this 20 post, my lord, our we have,
But why does your officers do all these things, just creating problem for everyone?
well, that's true, my lord, that's true.
If 20 posts were there, what was the need to mention this?
Correct, my lord. But this has been done in all the categories, my lord, in fact.
But why? They have their
True,
minds to apply.
True, my lord, true, my lord.
They don't do it.
Ought to have, they ought to have, my lord. They ought to have.
Lordship, I want to point out one thing, Lordship. In the at page 45, affidavit in opposition, first affidavit in opposition filed by the respondent, they have categorically mentioned that the petitioner was not selected. But in the second affidavit, it is page 61, petitioner and no other physically handicapped persons was participated. There is a contradictory stand of the respondent authority.
No post was reserved. No post was reserved for physically disabled persons with disability, because 20 posts, 3% comes to less than 1. That cannot be done.
Lordship,
All right, we'll close it now. There, nothing can be
Lordship,
done.
kindly make my submission. But I furnished the judgment on judgment. It is 2008 1 SCC 233. That is already furnished in the, it is in the record.
Yes.
Just operative part I'm saying, the appellant raised on GO so and so. The physically handicapped persons are those who are blind, deaf and dumb and otherwise handicapped. There were altogether 30 posts for which the selection was held. 2% of 30 is 0.6. So since 0.6 is more than half, we've round it off and hold it one out of the 30 posted reserved for physically handicapped persons.
No, so 2% of 20 is what?
2% of 20 is more than one.
2% of 20 is more than 1.
Sorry, less than.
Sorry?
It is 3%, Lordship. My case is not covered by that 2016 Act. It is 1995 Act. Then it was 3%. That is a matter of 2016.
No, no, but no posts were reserved.
They have mentioned in the advertisement, physically handicapped persons. And but the act is 1995, then it was 3%. It is a matter of 2014, advertisement was issued. And in the as part of 2016 act, it is 4%.
So what has happened? All the 20 posts have been filled up.
Those were filled up in 2016. In
What do you have to say on this? What he's arguing?
Our stand is that the petitioner there was no post for physically challenged person in that selection process. And subsequent, the second is that she was not called for the interview because she got lesser mark in the written. The information provided to us is that she has secured 17 marks and the last candidate who was called for the written, she secured 32 marks. That is why she was not.
No, no, but if she is otherwise entitled to benefit of reservation, then she will be in a different category.
In fact, in this particular selection, no post was there for physically challenged. But we have stated.
Correct, but that's what he's saying. In the advertisement, you have mentioned that you will reserve posts. So that would mean that the posts are reserved if as per the statute. Correct. So statute says 3%. So 3% of 20 posts is more than 5.5.
0.6.
0.6. So he is relying on this decision of Dev Sharma.
We have stated in the affidavit, in fact, we have brought the entire cadre stamp that out of that in 2013 there was a selection process for filling up
So how many posts of supervisors are there in total? Altogether under the department?
But we have filed an affidavit, Lordship, at page 85. Page 85.
Page 85.
Yes.
Yes.
Paragraph 2. Because Modi has filed the affidavit, paragraph 2.
Yes.
The total cadre strength of supervisor is 2280, including 1294 regular and 986 contractual. But this is for regular. Out of 986 of contractual post, 623 numbers earmarked for general area, and other than 6 schedule area, including BTAD and Karbi Anglong. The government has allowed 623 numbers of contractual supervisors to drop pay scale as per regular supervisor so and so, whichever from 29th of May 2019. It is respectfully stated that the Social Welfare Department has already appointed 19 numbers, that is 623, that the 3% of 623, that is 19. That we have annexed, that advertisement was of 2013. There was a special drive in 2013 where these 19 posts were filled up. After that, in 2014, this advertisement was issued where the post for physically disabled person were not kept.
No, but total strength is 2280.
They have the calculating the vacancy. Kindly see, page 64. Page 64 is the part of another affidavit. This is an advertisement. The affidavit starts at page 61. And page 64 is the advertisement, which is only for the physically challenged person in 2013. So when the special drive was carried out, after that in 2014, the 20 posts were approved, and that in those 20 posts, the physically challenged persons are not there.
No, what I'm saying is, what is the total cadre strength of supervisors under the department? Is this a state-wise cadre or district-wise cadre?
It is state-wise, except the BTAD and other 6 schedule area. Otherwise, it is.
So what is the total cadre strength?
Total cadre strength of supervisor is 2280.
2280.
Yes, sir.
Now, as per the statutory prescription, you are to reserve 3% of this 2280.
Yes, sir.
For being filled up by PWD candidates.
Yes, sir.
What is 3% of 2280? What is the figure? Can anybody just work out that?
Let's be kindly.
Just take your
sorry.
So it will be around 60 plus.
60. Got you.
Then what is this calculation given here by the director?
No, but at that point of time, out of 623, because the 1294 is the already the persons were there, my lord. The second
No,
subpara.
no, but that doesn't matter. We will see what is the total vacancy cadre strength and whether 3% has been exhausted or not. If not, you have to do it.
Well, in fact, a special drive was carried out. Special drive was carried out in 2005. And in that special drive, the posts were already filled up. And in 2013, they have calculated that 19 vacancies are there for physically challenged person. That is why
Give us the breakup now. You are saying there are 2280 number of posts.
Yes, yes.
So show us 60 minus 19. That would be. Where are those 39 candidates in supervisors? In the post of supervisor? Give us the figures. That ends the matter. If not, then you will have to consider
That I'll just the detail out of 2280.
So why this stand of the director in the affidavit? That's not correct. Why 600 something and why not the total cadre strength? Why is he left out the 1200 something?
Well, in fact, in 2012, in 2005, there was a special drive.
All right, but the number has to be the decisive factor.
Like in 2013, they have carried out a special drive. The petitioner did not participate in that. Well, in 2013, the page 64 Lordship has seen, this was for the physically challenged person only. For 19 posts at that point of time. I have followed, my lord, the out of the total calculations, what is the figure that I'll provide, my lord. But what I am submitting, my lord, that in 2013 at page 64, they have issued an advertisement, and this is for the application in standard form of application prescribed in Assam Gazette are invited for filling up vacancies against the post mentioned from candidates of persons with disabilities who are citizen of India to fulfill so and so, and kindly see supervisor posts are 19 posts, the total vacancies are 90 at that point of time.
So 19 is worked out of how many?
Out of 623 at that point of time.
Why not the remaining? Why the remaining?
The remaining are already filled up, already there, because in 2005 there were some process, and thereafter also, after calculating, because
therefore you show us that total cadre strength of 3% was already occupied by the PWD candidate. We'll close the matter.
Yes, the figure. The post earmark for the persons with disabilities, they are filling up from time to time by conducting special drive. Kindly see,
Mr. Nath, these are all fine. We are asking a very simple question.
True.
Tell us what is the total cadre strength and what is 3% of that? And also tell us that how many of those posts which comes to 3% has already been filled up. When you have done, how you have done, we are not getting into that. If there were still posts available within the 3% domain, then you have to give meaningful impact to the clause in the advertisement. Because you mentioned it. Why have you mentioned it? That means what? You have indicated that if the reservation statute provision applies, then you will give effect to it. So that will depend on whether on that day there were vacancies which were required to be filled up by PWD. If the vacancies were there, then we'll consider it as a violation of our right. If there was no vacancy, we'll close it. What is the big deal in this matter?
No, nothing. Like, I'll provide that figure.
We'll have it on Tuesday next. But so-and-so, Mr. N.M. Hazarika and Council for the Petition also, Mr. D. Nath and his senior government advocate Assam, who placed this matter again on 6th of February 2023, the 24th, so as to enable him to obtain updated instructions and appraise this scope. What is the total number of candidates recruited from the PWD, PWD category in the cadre of supervisor under the Department of Social Justice, including the regular as well as the contractual, regular and the contractual category? written instruction be obtained and placed before the court on the next date fixed. Total so and so on the date of issuance of the advertisement notice dated. What is the date of the advertisement?
Date of advertisement is not,
24/2/2014.
Is it 24/2/2014?
14.
Yes.
This is subsequent repetition, my lord, with a prayer for enforcement of the earlier order passed in WBC number
No,
6383.
that cannot be entertained. You can't file another requisition to enforce earlier order.
My lord,
Lordship,
as
his
per,
prayer has been rejected. We are filing our affidavit, gone for vetting, Lordship. His prayer has been rejected, Lordship, as per this, Lordship.
but affidavit has not been provided as my lord.
Lordship, affidavit that set
Prayer
for
for what?
vetting, for
Prayer-
compassionate appointment. After this WPC, Lordship, it
Then
has-
you challenge it.
My lord,
Give him a copy.
Lordship,
Huh?
Lordship,
Give him a copy.
Lordship.
Mr. So-and-so, your name, please?
MS Ali, my lord.
MS Ali Leonard, counsel is present for the petitioner. Mr. SS Roy Leonard,
CGC.
CGC appearing for the official respondents has produced a copy of the office order dated 04/09/2018 to submit that. In terms of the order of this court, the case of the petitioner has been considered, but his prayer for appointment on compassionate ground has been rejected.
Lordship.
Full stop. Since the order dated 04/09/2018 is not under challenge, this writ petition stands closed by granting leave to the petitioner to avail appropriate remedy as may be permissible under the law against the order dated 4/9/2018, if so advised. A copy of the order dated 4/9/2018 will be furnished to the petitioner's counsel.
Highly available.
Yes.
May please, your honor.
Yes.
No, this is a matter pertaining to selection to the post of motor vehicle inspector conducted by Assam Public Service Commission. The
Four
advertisement,
and five is connected.
no, my lord. Advertisement, your lordship will find page 23, annexure P1.
Page 23.
Yes, my lord.
Minute.
Name of the post, motor vehicle inspector.
Yes.
Page 23, my lord. Annexure P1, name of the post. Name of the post, motor vehicle inspector. A number of post 26. Now, we are concerned with down below serial number 5. Minimum qualification, minimum essential qualification. All applicants must fulfill the essential qualifications for the post and other conditions stipulated in this advertisement. They are advised to satisfy themselves before applying that they possess at least essential qualifications laid down for this post. No queries will be entertained related to the eligibility criteria by the commission. Then your lordship will kindly come to the next page, page 24. The qualification has been prescribed. It's SSLC with 3 years diploma in automobile or mechanical engineering from a recognized institute of Government of Assam, Government of India, and also duly recognized by AICTE. There is a note here, my lord, note 1. The prescribed qualification, prescribed essential qualifications are the minimum and mere position of the same does not entitle candidates to be called for interview. Now, the respondents, my lord, they issued a corrigendum after this advertisement that your lordship will find page 30.
by which the degree holders were allowed to participate against the post of MBA. Page 30. In continuation to this office advertisement dated so and so, and in pursuance to government letter dated so and so, it is for information that all concerned that the educational qualification for the post of motor vehicle inspector under the Commissioner of Transport Assam under Transport Department may be read as under HSLC. Previously, it was only HSSLC. Now HSLC stroke HSSLC with 3 years diploma automobile mechanical engineering or BE BTech automobile mechanical engineering from recognized Institute of Government of Assam, Government of India, and also recognized by AICTE. The intending candidates meeting the above mentioned modified educational qualification can apply. So we are the degree holders, my lord, we applied. Then, my lord, the government issued page 31 notice. This is for information to all concerned applicants who had applied for 26 number of post of motor vehicle inspector under Transport Department Assam in response to this advertisement number so and so dated so and so is hereby cancelled. So they cancelled the advertisement. Now thereafter they give a fresh advertisement. That you also will find page 32. Motor vehicle inspector under so and so 26 number of post. Down below, serial number 5, educational qualification, HSLC, HSSLC with 3 years diploma in automobile or mechanical engineering from a recognized Institute of Government of Assam, Government of India, and also duly recognized by AICTE. So pursuant to this advertisement, my lord, we were debarred from applying. Then we approached this honorable court. This honorable court allowed us to participate, and we participated in the examination. And out of the 6 petitioners, 4 came out successful. And four came out successful, and 4 posts your lordship was pleased to keep reserved for the petitioners in the event of their success. Now the issue is whether by virtue of acquiring degree, we have the qualification of diploma or not, my lord.
So any decided case law on that?
My lord, there are several case laws, my lord. Prior to that, I'll just take your lordships with the rule.
We'll do it post lunch.
My lord, yes, ma'am. I'm sorry.
What about other matters, item 5 and 6? Who's appearing? Item 5, item 6. What are these cases?
Item 5, I am appearing. In item 5, lordship, the petitioners are serving the forest department. They were granted promotions and their promotion orders were cancelled. That we have challenged, lordship, the cancellation of the promotion order.
Achha. Ready for hearing.
That-
Order due to which we could not, the registry is not,
If your
letting
lordship's
us to file
order,
an affidavit.
the lordship's order of 2911, they were directed to file their affidavit within 18th of December. As last chance. Prior to that, 29 for a last chance was given, then again a last chance was given, nothing has been filed. Last
So it is
occasion
an
also,
order-
same prayer was given on the month of January, that their affidavit is ready. Nothing has been.
Why didn't you file it?
Lordship, there was some defect in the affidavit, so hence it came back. And then we were asked to file a leave application.
Have
Again,
you served in copy?
no, your lord. But
If you
the
want
affidavit
it
is
on
ready.
record,
your
you have to
lordship.
make an application. Otherwise, you can't. Court order cannot be changed like this. You have to give a reason, explanation, and ask for modification of the order. Or else we'll proceed. What do you want to do?
Lordship, I'll pray for one last chance because we are.
No, but
we have
without
al-
an application, you will not get
No,
it.
we have filed for the leave application. That will just come to us after being signed.
Your clients are retiring when?
Retirement.
Then we'll see if the application is filed. What is your matter, Mr. Mukherjee?
Regarding compassionate family pension, your lordship, the PDCL on the last occasion was directed to bring instructions.
But have they got the instruction? Who is for the appeal? All right, we'll. Yes. So what does the rule say as per the
Well,
qualification?
rule says diploma, my lord.
Which page is the rule?
Yes, my lord, I'm just taking 54. The rule starts from, my lord, page 38, and the qualifications, your lordship will find page 54. District Transport Officer, first, that is graduate, degree is required, and thereafter Motor Vehicle Inspector, HSSLC, with 3 years diploma, HSLC is not there, in automobile or mechanical engineering from a recognized institute of Government of Assam, Government of India, and also duly recognized by AICTE.
So we are concerned with MVI here.
We are concerned with MBI here. My lord, I have an argument with regard to DTO, my lord. Just lordship will mark this degree qualification in the DTO, my lord. So rules prescribe for this. And our contention is that, my lord, basically, we are degree holders. We are not only in the higher pedestal, but also we are equivalent to a diploma holder. And to buttress my submission, my lord, I'm just placing one AICT regulation.
So are the rules under challenge?
No, my lord. I am not challenging the rule. My contention is, my lord, my contention is because this AICT regulation says 3 years diploma is equivalent to 1 year degree course.
No, but the rules do not permit equivalent qualification.
No, that's fine, my lord. Rules, my lord, rule says that diploma in so and so. Our contention is that we are equivalent to this diploma qualification because the AICTE, which is a technical body, my lord, established under the Act, my lord, it provides, if your lordships kindly take this gazette notification.
Yes.
Page number, my lord, 6. My lord, 467, my lord, bold page number written in the top.
There is no page number written.
My lord, in the top, it's 466 written bold.
No, nothing is written.
Yes. And this is the start of the notification.
Nothing is written.
My lord, then lordship will see. This is, my lord, here it starts. All India Council of Technical Education, my lord. Lordship will kindly. Or I'll
No,
just,
there is no page number. That's what I'm saying.
my lord, in my copy, small 466.
Your copy is for you.
I'm sorry, my lord. I make apology.
No, Mr. Das, I think the other day this matter was heard.
My lord, judgments are both sides, my lord.
Hmm.
There are judgments in my favor. One judgment, my friend is relying, para 26 and 27, my lord, Jarur Ahmed Rathar. My lord, they are propounding a submission that educational qualification, no business of the court. It is equivalence, it is the appointing authority or the expert. It is the duty of the expert. Court has no jurisdiction.
That's right. See the point. Let's come to the point.
Yes, my lord.
What matters. If the motor vehicle inspector's qualification was given as so-and-so or any equivalent qualification,
yes,
then the matter would have been entirely different.
True.
The court is not here to make legislation, correct?
Yes.
These are statutory rules.
Yes.
So they don't want any other category except for diploma in automobile or mechanical engineering. They don't want any other equivalent category also. It is their choice. So can this court say that no, not only diploma in automobile and mechanical, but you should have also considered others
There are
Although it is
instances-
not there, how can the
My lord,
courts?
there are judgments of, my lord, I'll
So
just,
many judgments.
yes. First of all, my lord, I'm taking your lordships to this notification to only to show that the diploma is equivalent to first year degree course. I am not saying, my lord, AICT is the,
Yes, yes, it is equivalent. Question is whether equivalent qualification is to be considered or not. It is equivalent. Let's take it that.
yes, my lord.
Then also, how can it be done?
My lord, if it's equivalent, if we are equivalent to a diploma holder, then, my lord, it can be taken up. The Honorable Supreme Court has said, my lord, I'll just take your lordships. First judgment, your lordships kindly take.
So when you refer to the judgment, please start with the rules. The language of the rule is what will matter.
Yes, my lord. Yes, definitely. First judgment, my lord, I am relying on rules, and another important aspect herein is that the nomenclature of the post, what post, my lord, is involved. That is also important in these matters, my lord. Supreme Court has also gone into that aspect of the matter. Because subsequent, the judgment my friend relied on, there is another judgment, subsequent judgment, my lord, wherein the Honorable Apex Court has dealt with that aspect of the matter. First judgment, my lord, will kindly take 2010-15 SCC.
And Mr. Das, you have to also understand, Supreme Court has powers under 142 and 141.
True.
The High Court doesn't have.
My lord,
So we will go by the ratio. What
Lordship.
is the ratio of the decision, not
Lordship.
what has been done.
Lordship.
What the Supreme Court has done in a particular case could be on the basis of enunciation of principles, or could be an order under 141, 142. I think it is 142.
142.
For ends of justice. That power we don't have. High Court doesn't have the power. Here the question would be only this and nothing more, that the rules are very clear and it does not leave any room for any expansion of the rules, because they have not said this or any other equivalent qualification. If the equivalent expression was there in the rules, that would broaden the entire horizon, and then the courts can get into and say that, well, this is equivalent and this ought to have been given. But here the question is not whether it is equivalent to this course or that. The question is they are not allowing any equivalent post. So you must understand the distinction. Maybe you understand.
I understand.
Yeah. So that is the problem here. They don't want any equivalent. So how does it matter whether it is equivalent or not?
Two lines of argument, my lord. First is that it is equivalent, that is. And second is that, my lord, since we are the degree holders, we acquire higher qualification. First of all, we are equivalent and we acquire higher qualification. So it presupposes the acquisition of the diploma degree. That is second line of argument. Third is that, my lord, if you want to debar a candidate from, my lord, submitting his or her candidature, in the instant advertisement or the rules, there is no restriction that degree holders cannot participate.
No, you can't argue that. You have not challenged the rules. That you can't argue.
No, I am not, my lord, that is not pursuant to challenge, my lord. My contention is that had there been some embargo in the rules, my lord, what my understanding is that if the rules has said that diploma in so-and-so, and we are equal to those diploma, and at the same time,
Mr. Das, the problem is we expect counsels like you to understand this. You must argue on principle in these matters. What is the principle?
Yes, ma'am.
First, let's look at the principle. Is the principle that regardless of what is there in the rules, you can look here, look there, and then expand the rule, bring things here? Or is the principle that this rule, although it mentions diploma in automobile or mechanical engineering, this would also mean any other equivalent degree? That argument you have to make it then, because prima facie the rules are not mentioning about.
I'll take your lordships to the judgments, my lord. Yes, lordship will kindly take first 2010-15 SCC.
Yes.
596, my lord.
What is the name of the party?
Jyoti KK and others versus Kerala Public Service Commission and others.
Yes.
Lord, the facts are para 2, my lord. The Kerala Public Service Commission invited applications for selection to the post of sub-engineers electrical
Yes.
in Kerala State Electricity Board as per notification dated 21/6/1994. The said notification provided that the qualifications for the post would be as follows. Para 2, technical qualifications, diploma in electrical engineering of a recognized institute after 3 years course of study. We are concerned with this, my lord. Then para 3, the appellants before us are holders of BTech degree in electrical engineering or bachelor's degree in electrical engineering. On the basis that the appellants did not possess the necessary qualification, the commission held that they were not eligible for selection. In the writ petitions, the same having been challenged, it was contended that they possess higher qualifications and therefore non-consideration of their cases is not correct. As they sought for a direction to the commission to consider them as eligible candidate, it was also pointed out that ever since the inception of the board, persons possessing higher qualifications have been considered and appointed in terms of Rule 13(1) of the Kerala State and Subordinate Service Rules 1956, and the board having accepted the higher qualifications to be applicable in all such cases could not exclude them in the present case.
So wait a minute, is there anyone who is a bachelor's degree holder who has ever been appointed as a MBI? Is that your case?
Sorry, my lord. This is.
No,
You will not be able to.
no one has been appointed yet, lordship, the degree holder.
No, my lord, we came into picture because of the change made by them. My lord, first they have issued an advertisement that minimum qualification, that is a diploma, my lord, higher secondary and
Change is
diploma.
gone, they have cancelled that.
They have cancelled that, then they have issued a corrigendum wherein, my lord, bachelor's
So
degree was.
if the corrigendum was not issued, then you would not have applied.
Yes, my lord.
Correct?
Yes.
Because before the corrigendum, you also knew that bachelor degree holders cannot apply. That's why you did not apply.
Yes, my lord.
Correct?
Yes.
And that is the correct position.
Yes.
Then they issued a corrigendum. Pursuant whereto you applied.
Yes.
But then that corrigendum was cancelled. Even the advertisement was cancelled.
Yes, my lord.
Thereafter, a fresh advertisement was issued. And that is strictly in accordance with the eligibility condition laid down in the rules. Now, you are saying that no. Interpret the rules in a manner which suits me. So even if I am not a diploma automobile or mechanical, even then I have a higher qualification. And therefore, my candidature needs to be accepted.
Yes.
As I have pointed out to you earlier also, the court has a mandate to interpret the statute. That mandate is very different from the mandate of the executives. Executives operate in a different field. The courts operate in a different field. The courts will see whether the action is arbitrary, illegal. That's all. Courts cannot say, and I am repeating it, if there is an order from any court, I will not follow it. The judges cannot say what they like. The judges will have to go by what is the correct position of law. Some order passed here, some order passed there, which may also have been implemented by the government for many reasons. It's a completely different matter. You have to convince the court on the principle. What is the principle? The principle is enunciated from the facts of the case. That is the ratio. If the ratio covers your case, I'll allow the repetition because I am bound by the ratio of a superior court.
Yes.
But if the facts are different, automatically here the argument is that others have been appointed and then it is SSLC or equivalent technical qualification, diploma in electrical engineering of a recognized institution after 3 years course of study. So, or a certificate in electrical engineering from any one of the recognized technical school shown below the 5 years service under this. So, a certificate in electrical engineering would also include a Bachelor of Engineering. That is also a certificate. So, in this case, the rules are far more wider, far more.
There is another
flexible.
wider, my lord, aspect in this rule, my lord, because this judgment was factually distinguished in subsequent judgment. I would have, my lord, taken to your lordships to this judgment. My lord, facts, my lord, some facts will be different in each judgment, my lord. Here also factual difference are there, but I'm relying on this to take your lordships because two ratios had been laid down in this judgment, my lord. If I take your lordships directly to that aspect, my lord, this point of
Mr. Das, rest assured that nobody will be more satisfied than the judges if this young man could be given
I
some
am,
relief.
that's for sure, my lord.
But our mandate is to pass judgments as per law,
Yes, my lord.
as per correct principle of law.
I'll try to assist your lordships, my
So
lord.
that
in-
this court will not budge from that.
I'll try
regardless of
to
what it is.
assist as best of my abilities,
Yes.
my lord. My lord, para 6 of the judgment, it provide, it incorporated a rule. My lord, on this rule, there is a liberty given to include higher qualification also. So in subsequent judgments, my lord, of the Honorable Apex Court, it was held that this Jyoti KK judgment was turned on the basis of this Rule 10A.
What is Rule 10A?
Rule 10A, your lordship will find para 6. Rule 10A2 reads as follows. Notwithstanding anything contained in this rule or in the special rules, the qualifications recognized by executive orders or standing orders of the government as equivalent as to a qualification specified for a post in the special rules, and such of those higher qualifications which presupposes the acquisition of lower qualification prescribed for the post shall also be sufficient for the post. So in the rule itself, it was provided that higher qualification will presuppose having the lower qualification. After that, para 7. It is no doubt true, as stated by the High Court, that when a qualification has been set out under the relevant rules, the same cannot be in any manner whittled down, or a different qualification cannot be adopted. The High Court is also justified in stating that the higher qualification must clearly indicate or presuppose the acquisition of the lower qualification prescribed for that post in order to attract that part of the rule to the effect that such of those higher qualifications which presuppose the acquisition of lower qualifications prescribed for the post shall also be sufficient for the post. If a person has acquired higher qualifications in the same faculty, such qualification can certainly be stated to presuppose the acquisition of the lower qualifications prescribed for the post. In this case, it may not be necessary to seek for. Since the rule has already provided, my lord, so Honorable Apex Court has held that we need not go further.
So this
is
decision
certain
really-
proposition of law.
But this decision really doesn't help you because there is a provision in the rule which permits.
I understand, my lord. I'm taking your lordship para 8 and 9, my lord. My lord, there are other two ratios are, my lord, laid down here, my lord. Under the relevant rules, for the post of assistant engineer, degree in electrical engineering of Kerala University or other equivalent qualification recognized or equivalent thereto has been prescribed. For a higher post, when a direct recruitment has to be held, the qualification that has to be obtained obviously gives an indication that such qualification is definitely higher qualification than what is prescribed for the lower post, namely for the post of sub-engineer. In that view of the matter, the qualification of degree in electrical engineering presupposes the acquisition of the lower qualification of diploma in that subject prescribed for the post shall be considered to be sufficient for the post. The Honorable Apex Court says that it's sufficient for the post. Then para 9. In the event the government is of the view that the only diploma holders should have applied to post of sub-engineers, but not all those who possess higher qualification, either this rule should have been excluded in respect of candidates who possess higher qualifications, or the position should have been made clear that degree holders shall not be eligible to apply for such posts. When that position is not clear, but on the other hand, the rules do not disqualify per se the holders of higher qualifications in the same faculty, it becomes clear that the rules could be understood in an appropriate manner as stated above. In that view of the matter, the order of the High Court cannot be sustained. In this case, we are not concerned with the question whether all those who possesses such qualification could have applied or not. When statutory rules have been published and those rules are applicable, it presupposes that everyone concerned with such appointments will be aware of such rules and make himself aware of the rules before making appropriate applications. The High Court therefore is not justified in holding that the recruitment of the appellant would amount to fraud on public. Such of those eligible degree holders who fulfill the qualification referred to above and found suitable to be appointed shall be appointed, taking note of the vacancies which are available within a period of 3 months. So, my lord, in
It
para
has
eight-
been held, in fact, I was just about to say that now if the rules are interpreted to mean that equivalent degree is also permissible, then it will amount to fraud on public. I was about to say this.
that was the
So then I
argument
find
made,
that
my lord.
This is already there.
That was an argument made, my lord. In para 8, what the Honorable Appeals Court has said, if in the higher post, degree is prescribed, in the context of this rule, my lord, if in the higher post degree is prescribed, why not, my lord, it is considered equivalent with the lower, for the lower post, that is in here in
The answer is
sub-engineer
very
as
simple.
sufficient.
That question the courts cannot ask. I'm not commenting on the order of the Honorable Supreme Court. We can't ask this question. Why don't you change the rule? Why don't you make it like that? Why don't you make it like that? We can't. That's not
Appeals
the
Court said that is sufficient, my lord. Going by the nature of the case, the Honorable Appeals Court said that this is sufficient. That word has been used, my lord, that's sufficient for the post in para 8 last line, my lord. And second contention, second ratio, the Honorable Appeals Court has laid down that had there been any restriction in the rules in para 9, had there been any restriction on the rules that yes, the degree holders cannot participate, in that event, my lord, there could have been.
So even the Master of Arts or Fine Arts, they should have been allowed to participate because there is nothing in the rule saying that the music graduates cannot.
My contention is not that, my lord. I again come to this notification, my lord, of AICTE, because AICTE being the highest authority has already decided and gave a decision that 3-year diploma is equivalent to the 1-year degree course. So the moment we complete 1-year degree course, we are equivalent to a 3-year diploma holder.
So you mean to say that anybody joins BE and studies for 1 year, he can exit the course with a certificate that he is a diploma holder? Is that your
That is the mandate of the, my lord. I am not saying, my lord, it is the AICTE has, because there is a provision of lateral entry, my lord. AICTE has provided that diploma holders can also go for degree course. There is a lateral entry for the diploma holders in the degree course. In that context, my lord, the AICTE has provided that 3-year diploma is equivalent to 1-year degree course, my lord. My lord will have a look at that notification, my lord.
Yes, but please paginate it, huh? Because otherwise it's very difficult.
I'm giving
You
my lord.
paginate it for yourself, not for the.
I'm sorry. I'm sorry. Lower one. Pagination. Pagination.
a mark for this.
What is this notification about?
This is not, issued by All India Council of Technical Education in exercise of powers conferred by subsection 1 of section 23, read with section so and so of All India Council for Technical Education Act 1987, following regulations are notified by the, this is basically a regulation of the AICTE. Milord.
And which is the relevant part?
I have marked it, Milord, in the next page. 6(1)(b) eligibility, Lordship will kindly come to the third paragraph. A student who has acquired a diploma in engineering through a minimum of 3 years institutional study after 10+2 secondary school leaving certificate examination can be considered to be academically equivalent to a student who has passed the first year of the four-year engineering degree program for which the qualifying exam is to be 12+ level.
So that is for lateral entry, academic equivalence. That is not the equivalence of educational qualification. This is academic equivalence.
True, Milord. Or if what my submission is that if a diploma holder can make a lateral entry to the regular degree course by virtue of, Milord, the sayings of the AICTE, Milord,
That's what I'm saying. You can't argue these things because you have not challenged the rules. Whether the rules are rightly drafted or not, you cannot argue that. That's not under challenge. The rules have to be treated as it is. Now the court has to see whether there is any scope to interpret the rules in a manner to include any other equivalent degree. That's the only question will be answered in this case. Nothing else. Only question. So this notification you have relied upon, this is the notification which deals with eligibility for lateral entry. At which stage a student can enter, and if he enters, what will be the academic equivalence of the course he has already pursued. So obviously, one can do 3-year diploma course and then join a Bachelor of Engineering course. So there has to be some benchmark. When will you allow him to enter, with what credit? So it is all for all these purposes, this regulation has been laid down. So if you have done your 3 years diploma, then you will be treated to be academically proficient to join the second year of BE.
Second year of BE.
So therefore therefore every BE who has passed first year is a diploma holder. That's
no, it's not a diploma holder. I'm not saying that, Milord, I am the diploma holder.
You are more qualified by them.
First of all, more qualified.
That's not the point.
And when I complete first year, I become equivalent to a diploma holder.
You are more qualified.
More qualified is
But
there.
that's not the point. Point is not whether you are more qualified or less qualified. Point is whether do you have the qualification as prescribed by the if it was a case of master's degree, say the advertisement said that you have to be a Bachelor of Arts in economics. You are a MA economics, you apply, and they say, sorry, you can't. The case would be totally different because you can't do your MA without your BA. That is a structured format of degree, and you have a certificate of BA before you make your MA. So therefore, you leave out your MA, master's degree, even you have a bachelor's degree certificate. So you meet the requirement of the rule. You may be overqualified, but here you do not meet the requirement of the rule. You may have pursued a course which has got a higher academic value, higher value in the professional field, but it is not the same qualification as prescribed in the rules, and the rules are not under challenge. So if the court has to say that, all right, diploma will also include B, then that would amount to legislation by the court, which is not permissible under the law. That is the problem you are facing. That is the problem. And either you have understood the problem but don't have an answer, or I don't know what to say.
No, I have understood. I have understood.
That's the problem. You hit the nail on the head and get an order from us. There's no difficulty. I have told you, no one will be happier to see that these boys
That's
who are
true.
qualified
That's true.
are absorbed.
That's
But this is a writ code. We lay down precedents. We cannot do things which are not technically and legally correct. It will be a wrong according to the court. Now, of course, if you have anything else to argue, you are most welcome.
Lord, one judgment, after the Rathar judgment, there is another judgment of Supreme Court, recent judgment, Punit Sharma. If your lordships kindly have a look.
Yes, yes.
Yes.
Yes, why not? If there is
Factually-
anything which throws light on this, if there is a
In fact,
decided case in the Supreme Court which comes into play, then I am bound to follow that. I will.
Lord, I must admit before your lordships that there will be some factual differences, but the
Now,
ratio.
for example, this judgment is not applicable in your case.
My lord, this judgment, I have also doubt because subsequent judgment, my lord, I'm just para
When
8
the
and
court
9.
is saying it is not applicable, what are you saying you have doubt?
No, no.
I will lay down that it is not
Your
applicable.
lordship
You
is
don't have
correct.
a choice.
No, yes, your lordship is correct.
You are
sir.
having doubt on
I'm
the
sorry.
court or on the
No,
judgment?
no. That can't be, my lord.
Hmm.
I'm sorry, my
It is
lord.
not applicable because there is a provision which says
There is
that
a provision and
equivalent degree will also
on
be
that
considered.
count, my lord, in Jarur Ahmed Rathar, the Honorable Apex Court has, that was turned on the basis of Rule 10(1). So, in Anita and other judgment, it was factually distinguished. The ratio has been kept, my lord, same. In appropriate case, if rule provides, then this will apply, but factually distinguished, my lord.
That's the
My lord,
ratio.
In
That's the ratio.
Punit Sharma, that is 2021 SCC online SC.
What is the meaning of ratio, Mr. Das?
Ratio is the reasons assigned in the judgment, my lord.
Hmm.
The reasons assigned in the judgment on the basis of which the conclusion has
Yes.
come.
So if the facts of a case on the fundamental aspects is different than another case, then ratio of that case will not be applicable to this case.
That's true, my lord. That is a settled position of law.
So
But
in this case,
another
that is KK, Jyoti
Jyoti
KK,
KK.
These rules, as we have already discussed, clearly says that equivalent posts can be considered.
Consider.
So that itself opens up. If one line was added in this, that this or equivalent, the matter would have been completely different. Perhaps they also wanted it.
In fact, Transport Department, they wanted it. In the affidavit, it has come up. They wanted it. Then Judicial Department pursued the Transport Department twice that you are committing a wrong. Then thereafter it was cancelled. In fact, my lord, my instruction is that they are going to amend the rule also. That is my instruction from the client. It is under process.
That is different issue. Subsequently, we may
But
amend
if the
the
rule is amended also, you will not come in with by this election. You cannot
Yes,
come
my
in.
lord.
If the rules are amended, then not only you 6, there will be 60,000 others will come
Yes.
in. So you can't come in through a process which is not legitimate.
My lord, same thing in Punit Sharma, same thing happened, my lord. They have challenged here also degree and diploma was the issue, my lord.
No,
And-
you have to show me which is the rule.
Yes, my lord.
Degree and diploma is the issue in 1,600 cases.
Yes.
But what is the rule? Does it allow an equivalent post or not? That's the point.
No, same problem that we are facing here, my lord. Same problem was in this case also, my lord. Then Honorable Apex Court, my lord.
What is the party's name here?
Punit Sharma and others.
Okay, let us have a look at the rule.
2021 SSC Online 291. I have given.
Yes, it is there.
Yes, ma'am.
You are referring to which paragraph?
Paragraph 2, the facts, my lord, then rules. 2 and 3 are the bare facts, my lord. What was the issue before the Honorable Apex Court? Where a degree in electrical engineering, electrical and electronics engineering is technically a higher qualification than diploma in that discipline, and whether degree holders are eligible for appointment to the post of junior engineer under the relevant recruitment rules, is the issue that falls for a decision in this appeal arising out of the common judgment and order of the Himachal Pradesh High Court.
All right, where is the rule? Just take
Yes,
us
I'll
through.
just take your lordship to the rule.
Which paragraph?
Para 13.
Para 13?
Yes, my lord. Junior engineer substation, junior engineer, then in the trade concern who are
Where is the educational qualification?
diploma with 7 years service in the grade. Then ITI qualified having 12 years service in the trade. This was the issue involved. ITI and diploma holder. Then
But read number 3, Roman
yes,
3.
from amongst those persons who pass acquire the qualification of AMI or who acquire full-time regular degree in electrical engineering, electrical and electronic engineering, computer science engineering, electronic and communication engineering, and information technology in service after confirmation to service to the extent of 5%.
So this is very different. How
This is, Milord, we are concerned with Roman 2, first para.
No, the
Their
petitioners
qualification.
Petitioners are degree holders, is it not?
Yes, my lord.
So the rules permit them to.
No, my lord. If I'll just. Permit. There was an argument.
Thus, I'm asking you, I can give you one more chance for about 3 days or so. Otherwise, difficult. Because saying things which are not hitting the nail in the head, we can do it for another 20 minutes. But you're not addressing the court on the relevant issue here. If you don't have an answer, let's put it in a halt. Because I am also seriously looking at giving some relief to the petitioners. But I will not pass an order which is not in accordance with law, to my understanding. That is the principle I have followed as a judge, and I am going to follow it.
Yes, I'll not,
Orders have
I'll
to
not
be
persuade your lordships, my lord.
based on principles which are judicially established principles. There you are free to argue and tell the court that the correct principle is this. And if you succeed or convince the court, I'll accept it. But so far you are moving on a different track. The fundamental point, as I have been mentioning again and again, because as a matter of fact, I'm also thinking how, and they have come so near, they have cleared, 4 of them have cleared. So I understand what will go through them, but that cannot be a ground. We have to pass orders which the government has no option but to implement. That is not to say that what the government does, that will depend, but our orders have to be technically correct.
True.
We have to pass orders to the best of our knowledge, understanding, and ability, which are sound on legal principles and technically correct. But if the government feels that these orders are questionable, and then this is not helping anyone, more litigations, and this becomes a completely chancy affair. But that is another matter. What happens later, we don't know. But that is the question. The Reed court cannot legislate. This court cannot legislate. Once the rules say it is either this or that, then you have to possess that qualification. If you do it, you are in. If you don't do it and you are a rocket scientist, you cannot. So what I'm saying is, a NASA scientist is not eligible to be appointed as the MBI. That's the law. Cannot be. Does he know anything less than a diploma engineer?
No.
But if he is a MTech and works in NASA and applies for MBA, he cannot be appointed. So it is not our job to see whether he would have been this, he would have been that, how big he is, how qualified he would. That's not our job. Our job is the action of the government arbitrary and illegal? That is what we have to see. Our jurisdiction is confined to testing these actions on the touchstone of Article 14, 16, and sometimes Article 21.
Yes, ma'am.
Correct. So if the court finds that there is an infraction of the rights on this touchstone, we will definitely step in. That's the mandate of the court. But what should have been, what could have been, how they could have been a little better, that the law doesn't permit. That's the unfortunate reality. Otherwise, there will be chaos. Judicial department is right. Maybe you're right. The department wants to expand it because there is a huge unemployment problem. Why not? If you can allow diploma holders, why can't bachelor's degree holder come in?
They are more.
Yes, logically, nobody can agree more with you. But we have to go legally.
True, my lord.
Legally, and we have to issue a mandamus.
Yes.
Mandamus is issued to compel the authorities to perform their duties under the law. Their law must enjoin a duty. They must have failed to perform that duty. And then the court will enforce the right, issue a mandamus to compel the authorities to perform their duty. If they have done something which is in accordance with law, where is the scope for the court to issue a mandamus? The department tried to do something which is inconsistent with the rules. Judicial department pointed out, they realized their mistake. They rectified it. And that's where you are. How can we now tell them to act contrary to the rules? The writ court cannot pass a writ of mandamus contrary to the rules. That's not because this is an equitable jurisdiction.
Yes, ma'am.
Please do the readings and then you will understand why the judge is speaking in a particular
Lordship
manner.
says.
We
the
cannot
query
direct them to
fallen-
do anything which is contrary to the rules and law, and these are statutory rules. The moment we do it, we'll be transgressing our limits. That will be wrong, and the court cannot knowingly do something which is wrong. So that's why I said as a judge, I would definitely be very happy if some young man could be given an appointment, but then if the legal position does not support their claim, what can be done? We have to administer justice as per law. So this is the long and short of your matter. There is no point going here and there. If you have any answer for this, then you have a relook. I'm considering the sensitivity and that it's a
Yes.
question of future of at least four.
Four boys.
Two are gone already. They have not qualified.
No, not qualified.
So four young men, they are aspiring. It's a very, very
Well, I'll try
difficult
one
world
chance,
for
my lord.
today.
I'll try one chance. I'll again. my
But
lord,
you have to
through-
meet the arguments there. Today and yesterday, you have not argued anything which is on the main point.
Yes, my lord.
And on top of that, you have not challenged the rules. We cannot even read down the rules, and we will not permit you to do it now.
No, my lord.
We cannot even read down the rules.
So far as the government, whatever government has done, if we have a plain look at it, my lord, there is no wrong, lord.
That's-
Absolutely correct.
That's what I'm saying.
But what I was trying to, my lord, project before your lordship is that apart from that rule position, my lord, by virtue of the judgments of the Honorable Apex Court, a limb has been opened which can be taken, that was, I was trying. Well, I will again try, my lord, to just try to develop on that.
You read the fine prints in the judgment. Both the judgments you relied upon do not apply in your case.
No, second, I'll try to, my lord, again persuade your lordship. First, I can, my lord, I can.
The second one, the rules admit Bachelor of Engineering. Only the percentage quota is different.
There are
Somewhere
other-
it is 10%, somewhere 15%.
That is for the promotional post, my lord. I'll address, my lord, not today, my lord. I'll take your lordship with a, my lord, relook of the, or a fresh look of the rules, my lord, in this matter. And there are two more judgments of, my lord. One is of High Court.
All right. But as a young counsel, upcoming counsel,
I'll do some
please
more
remember
homework.
this. A writ of mandamus will not lie, asking the authorities to act contrary to the law or the rules. That kind of a writ will not lie.
No,
That is not the jurisdiction of the court.
that is not.
It is rather the other way around. If the law shows that this is what they are entitled to and it has not been done, then the courts can issue writ to compel them to perform their duties. By clearly laying down that this was the duty, this is the infraction, this is where things have gone wrong. So now rectify it, do this. Then it becomes a prerogative writ.
Yes.
But if they have done something which is in consonance with the rules, if there is no prayer to set aside or interfere with the rules, so the rules remain as they are. Correct. And rules do not admit of any equivalent position. Thirdly, your UGC or AICT circular, it is only meant for lateral entry academic equivalent. What has this got to do with in the context of the rules? it has
In
got-
one of the judgments of Milord, that was
Ah.
relied on. So that's why I'll just.
One last chance, fixed part on Thursday. And
I'll
there
just
is
work
no-
on it, Milord. I'll just try.
No,
The
no,
question
it's
your
not-
lordship says pause, Milord. It's really a difficult question. It's not an easy task.
No,
But even then, I'll try my best.
we would want you to come with an answer.
Yes, Milord.
But if you can't, then the verdict will go against your clients.
Yes, Milord. I'll
But
try.
we would want you to.
Yes, yes.
Because as I've already mentioned, we are conscious today's world employment is so difficult. They are engineers, all they are seeking is
Idle.
participate and but then that's the law. That's what the law is.
Yes.
Party presence video list again Thursday, fixed parted matter.
My lord,
Mal-
deeply obliged.
So far you have not been tested. But one question we would like to know. Why did you issue the corriendum?
Lordship, because we have taken views from the judicial department, the original report is with us.
Hmm.
They said, yeah, if you want to implement the graduate engineer, you have to amend the rule first. After that, only you can do that. After this judicial
So
department.
now
view-
what you want to amend the rules?
Lordship, that instruction I don't have, but if you amend the rule subsequently, but this is not related to this matter, my lord.
So if you want to amend the rules, then we can think of holding some relief.
That instruction I will
They are
get.
not bad candidates.
Lordship.
So why hide behind technicalities?
Lordship, I will get that instruction also before Thursday, if they are going to amend this rule, and Lordship may. My lord.
In fact, Milord, after the ICT notification, I have annexed, Milord, rules of the other states of the country, Milord. In all the other states in the country, 5-7, I have annexed, Milord. All degree has been included, Milord. Advertisement, I have annexed.
No, that is fine, but here, that's why it is required to include.
Yes.
Otherwise, AICT, otherwise diploma would have got through in all those cases.
Milord,
What was the need to include?
That's why.
And even if it is amended, now it cannot be done. Because others will come and complain that had we
Yes.
known, we would have applied.
Problems are there, Milord. Not
Equitable
many problems
jurisdiction is
for.
a very, very double-edged sword.
But 2003 onwards, Milord, there were attempts made to amend the rule to include degree. Somehow that did not.
That is another matter that
Yes.
they have their right, wrong, good, bad reasons. We can't comment on that.
True.
All right, next matter.
Deeply obliged, my lord.
Highly.
May it please your lordship, pursuant to last order, we had given a leave application to the department, which is yet, which will be received today, from what I have
No,
learned.
no, you are taking your own time.
This has been
You have
going
no
on.
respect for the court's order.
Lordship, otherwise, everything is ready, lordship. Only that leave application, that will be filed by next week, lordship.
No, but your right to filing affidavit is already gone.
If lordship grants the
How
leave,
can I grant? The order is already there.
And this petitioner, sir.
You have to file an application, you have to give an explanation. If the explanation is not found to be sufficient, it will be rejected. But then you have not filed any explanations, any application.
we just seek one more week, lordship.
With this
It will be
promotion
fine.
orders since 2021, they are serving in a subordinate capacity, lordship. Quite a-
There's, how many petitioners here?
Lordship, 7 of them, lordship.
They are all serving as what?
Lordship, they were promoted, they had joined as forest guard, subsequently promoted as forester grade 1. Now, after cancellation of the promotion order, they are again working as forest guards, lordship.
Promotion was given to them.
Promotion was given, then kept in abeyance, and then without hearing us, that was cancelled.
Why it was cancelled?
Lordship, if I may take your lordship through the speaking order, lordship. That is at page, lordship. Page 37, lordship.
Yes.
Their contention is that, lordship, we were imparted 6-month course, lordship. 6-month training course. And the rules provide that whoever secures first, second, and third position and secures 70% marks, they will be promoted to forester grade 1. Now they say that on not only the 6-month course, but the 3-month course also is eligible. They nowhere say that we are not eligible, Lordship. They say that 3-month course is also eligible, but they have
Which is the impugned order, page
Lordship,
number?
page 37, Lordship. The speaking order,
Yes,
Lordship. May I read, Lord?
yes, please.
Lordship. Lordship, this office order dated so and so, dated 29/6/21, wherein 12 number of forester agreement. Lordship, we are forest guard. We are covered by the next portion, Lordship. Where above in the final examination of forester training course were promoted, and above in the final examination of 6 months induction training of forester guard training course and completed 5 years service were promoted to the rank of forester grade 1. The last line, Lordship, of paragraph 1. We were promoted from forest guard to forester grade 1. Now, Lordship, if your Lordship kindly comes to page 38, the relevant portion. Page 38, Lordship.
Yes. Yes, please.
Lordship, 11th line from the top, Lordship. It starts from similarly in the case of. 11th line from the top, Lord. It starts with similarly.
Yes,
Lordship.
yes.
Lordship. Similarly, in case of forest guards, a batch with 3 months training has not been considered for promotion. Backlog of untrained staff, Forester 1 and Forest Guards imparted 3 months training as per revised training rules, and having performed meritoriously on academic grounds and had been deprived of promotion, which new recruits could avail despite getting lower marks than former. Then, Lordship, in the same paragraph, Lordship, in the last portion, they say that since the revised training rules dated so and so and the subsequent approvals dated so and so and the letter dated so and so do not deal with these issues, the need for amending the Assam Junior Forest Service Rule 2005 persists. Lordship, on the ground of a purported amendment which may be required in future, promotions granted to us have been cancelled. And it is not the case that we had not fulfilled.
So 1 minute,
Lordship.
your clients are all forest guards.
Forest guards, Lordship.
They were promoted as foresters,
Grade 1, Lordship.
grade 1.
Lordship.
And what is the date of promotion?
Lordship, the date of promotion is, Lordship.
Which is the
Lordship, yes. Lordship, page 30, Lordship. 30. 29/6/2021. Lordship, serial number 1 is not before your Lordship. Serial number 2 to 8 are the petitioners. Serial numbers 2 to 8, Lordship.
So there are 7 of them.
7 of them, Lordship.
And what is where is the order of cancellation?
Lordship. Your Lordship, that the speaking order, which starts at page 37, which I taken your Lordship through, the order is at page 39. The findings, Lordship. Page 39, Lordship. The last portion.
This is the impugned order.
This is the impugned order. Page 37 is the impugned order, Lordship. It continues till page 39. Page 39, Lordship. At the bottom, it's there, Lordship. In view of the gross violations of the provisions laid down in Rule 61A, 1 and 61B2 and 6 of the Assam Junior Forest Service Rule 2005, the promotion order issued by Office Order number 581 and 582 dated 29/6/2021 is hereby cancelled. Your Lordship will kindly see the findings. Paragraph B.
So your clients were promoted based on recommendation of some selection committee.
Lordship, the rules of the Assam Junior Forest Service rules provide that whoever attends the training course, whoever attends first, second, and third position, and whoever gets a minimum of 70% marks, they will be promoted to Forester grade 1. Accordingly, we had joined the training course, we had completed as first, second, and third, and above 70% marks, and
That's
accordingly.
right, but there has to be a process of promotion.
Lordship.
What was the process here?
Lordship.
Rule says this means this makes you eligible.
Lordship.
But you cannot self-appoint yourself as forester.
No, Lordship. After I qualify for this, Lordship, 40% post is reserved for promotion in this manner. And our 12 batches, the immediate.
Mr. Chakravarti,
Lordship.
what I am asking is,
Lordship.
what is the exercise which preceded this order at page 30? This has to follow some procedure, right?
Lordship.
What is the procedure that was followed? Or somebody can just
Lordship,
take out a notification, promote 10 people for various reasons, which can be bona fide, not bona
Lordship,
fide.
as per my instructions, Lordship, after every training course, Lordship, the persons who are eligible, who have qualified this stipulated criteria, they are promoted, Lordship. And accordingly, our previous batch was promoted, thereafter our batch was promoted, and this has been going on. Lordship, with the previous batch promotion orders also I have annexed, Lordship. After every batch, Lordship, whoever qualifies this criteria for second, third, and 70%, they are promoted as Forester grade 1. That is the condition, Lordship.
So according to them, only 6 months, people who have undergone 6 months training can be promoted.
Promoted.
And your clients have undergone 3 months training.
We have completed 6 months. Lordship. Their cases, 3 months are also eligible. And therefore, we have superseded those who have undergone 3 months promotion. But in the rules, Lordship, there is nothing that. And
Where are the rules? Let us see. Is it a part of the record?
Lordship, the Assam Forest. Lordship, will kindly see 6(1)(b)(1), Lordship, on the right hand side. I've marked it, Lordship. It states, Lordship, may I read? 40% of the posts in the cadre of Forester grade 1 shall be filled up by promotion from the rank of Forester grade 2 head game watcher of equivalent rank set and status satisfying the following conditions. Forester guard oblique game watcher trainees securing first, second, and third position with marks not less than 70% in the final examination of the Forest Guards training school and with a continuous service length of not less than 5 years. Accordingly, upon completion of this condition, Lordship, we were promoted. Now, Lordship, that has been cancelled. They say that we have superseded batches since 1920, but even our senior batch in the training school have been promoted and we have annexed that order, Lordship. That is at page 44. So there is no supersession of batches, Lordship.
This percentage of marks is scored in which exam?
In the training school final examination, Lordship.
Yes. What is your submission?
Lordship, according to the affidavit that we thought to
That
file.
will not come here because I'm disposing the matter right now.
Lordship, three things were violated while that promotion order was issued. Firstly, Lordship, that selection committee was not constituted as per Assam Junior Forest Service rules. The second one is that they should have a length of 10 years of service, and within that 3 years should be in wildlife division, which was also not fulfilled in these candidates' cases. And thirdly, Lordship, that training thing, what happened was that they were appointed in 2006, and just before that, the training duration used to be 6 months, but after that, it was reduced to 3 months. However, when this merit cum seniority list was prepared, their seniors were left out just because they spent more time in their training school, Lordship.
So then that is not a ground to cancel their promotion.
But Lordship, the first few points are still
And
very
that too
relevant.
without
Yes.
hearing them. Violation of principles of natural justice.
There's a report.
Give them a chance of being heard. We'll set aside this order. Serve notice on them. Give them an opportunity. You cannot act arbitrarily. Heard Mr. A. Chakravarti and any counsel appearing for the writ petition. I've also heard Mr. I.P.
Bhattakur.
I. Bhattakur,
Yes.
Learned Standing Counsel Forest Department as well. Appearing on behalf of
Mr. P.N. Nusami.
the respondents. Full stop.
Yes.
7 writ petitioners who were serving as forest guards and were promoted to the post of foresters grade 1 have approached this court assailing the order dated 2/7/2022, speaking order dated 2/7/2022, issued by the respondent number 2, cancelling the promotion given to these petitioners by the earlier order dated 29 June 2021. Full stop. The impugned order dated 2/7/2022 has been primarily assailed on the ground that the same was issued by the authorities without serving any prior notice or giving any opportunity of being heard to the petitioners, thus causing serious prejudice to their interest. Full stop. Mr. Chakraborty, learned counsel for the petitioner, has submitted that his clients are qualified under Rule 6 of the Assam Junior Forest Service, Forest Service Rules, 2005, bracket, hereinafter referred to as the Rules of 2005, for being promoted to the next higher rank of Forester Grade 1, and they fulfill the requirements of Rule 6, bracket, numerical 1, capital numerical 1, bracket close, then small b, bracket close, of the rules, notwithstanding the same, and merely because, according to the authorities, some other forest guards were also eligible for being considered for promotion, the impugned order has been issued by the respondent number 2, thus depriving the petitioners of the order of promotion earlier passed in their favor on 29/6/2021. Full stop. The respondents have not filed any affidavit. Full stop. Affidavit, despite several opportunities being granted to them by this court. Full stop. On 29/11/2013, this court had passed an order granting them time till 18/12/2023 on the request of the learned departmental counsel, to file affidavit by making it clear that if no affidavit is filed within the said date, the right of the respondents to file affidavit would stand struck off, within quotes, struck off. Full stop. Notwithstanding the above order, neither any affidavit has been filed, nor is there any application for recall, public review, public modification of the order dated 29/11/2023. Be that as it may, from the operative part of the impugned order dated 2/7/2022, I find that the promotion given to the petitioners by order dated 2/7/2022 has been unilaterally cancelled by the respondent number 2 on the following grounds. On the following grounds and findings. Full stop. Findings. And quote page 39, findings, double tick to double tick. Full stop. Insofar as the first ground is concerned, Mr. Chakraborty has argued that all proper procedure as prescribed by Rule 6, bracket 2 has been followed before promoting his clients, and therefore the aforesaid ground is wholly untenable. According to Mr. Chakraborty, if a show cause notice was served upon his clients, giving them an opportunity of being heard, his said aspect of the matter would have been pointed out. Full stop. Similar is his submission with regard to ground number 2 mentioned in the impugned order dated 2/7/2022. In the absence of any counter affidavit filed by the department, this court does not find any justifiable ground so as to reject the aforesaid submission of the petitioner's counsel. Stop. Coming to the third ground, as indicated in the operative part of the order dated 2/7/2022. It is to be noted herein that there is no allegation against the petitioners that they have not undergone this 6 months training, which is a prerequisite for being considered for promotion to Forester Grade 1. Full stop. Rather, the stand of the departmental authorities is that other senior forest guards who have undergone 3 months training period was eligible for being considered for promotion ahead of the petitioners under the rules, but their cases have not been considered. Full stop. Hence, the promotion of the petitioners was unsustainable in the eye of law. Full stop. After a careful scrutiny of Rule 6 of the Rules of 2005, I do not find any provision which permits forest guards completing 3 months training to be promoted in the next higher rank. Full stop. Moreover, even if it is assumed that other senior forest guards were eligible for being considered for promotion, the promotion already given and notified, promotion already given to the petitioners and notified by the competent authority could not have been revoked in this fashion without giving an opportunity of being heard to the petitioners. Under the circumstances, this court is of the unhesitant opinion that the order dated 2/7/2022 is not only illegal, but same is also in violation of the principles of natural justice, making the same completely unsustainable in the eyes of law. Consequently, the order dated 2/7/2022 stands set aside. The earlier order dated 29/6/2021 stands restored to its original file. All consequential benefits be given to the petitioners accordingly. Full stop. However, before parting with the records, it is clarified that in the event the authorities are of the view that the writ petitioners were not eligible or entitled to be promoted to the next higher rank, and the order of promotion is required to be modified, revoked for any good reason, the same will be done only after serving prior notice upon the petitioners and giving them an opportunity of being heard in the matter. With the above observation, the writ petitions.
Lordship, there was also an order of abeyance that also may be satisfied.
Order of?
Order of abeyance, keeping our promotion orders in abeyance prior to issuance of this consideration order.
Consequently, the order dated, which is the order?
Lordship, Annexure A4, order dated 3/7/2021, page 32. Page
Once set aside, order dated 2/7/2022 stands set aside. Consequently, the order dated 3/7/2021. Achha. Oh, there was an order keeping it in abeyance.
Abeyance, and then it was cancelled.
Oh, you didn't point it out.
I beg your pardon, Lordship.
I will not interfere with that order.
Lordship. As your Lordship pleases me.
Why was it kept in abeyance?
Lordship, there was no show cause to us.
Consequently, the order dated 3/7/2021, keeping the order of promotion in abeyance, would also stand interfered with. Baki, you continue. But they can serve fresh notice.
Lordship, oblige, Lordship. Much obliged. Much obliged.
Item 6.
Here, Lordship, we have a set of instructions what has happened is that after 2014, compassionate appointment was done away with in APDSL, and which was replaced by compassionate family pension. However, Lordship, the minimum service period requirement is 2 years, but here in this case, the petitioner has not, petitioner's husband did not fulfill that eligibility.
How long was he employed?
As per
1 year, 11 months, 6 days. 1 year, 11 months and 6 days.
He does not meet the requirement.
As per the oral instruction that we have received, Your Lordship, I have not received the copy, I have not found a copy of that by which the previous scheme for compassionate appointment is done away with. In my understanding, that is still there, Your Lordship.
Then you have to file an affidavit, Mr. Bhattakur.
Yes, we'll file an affidavit.
Let him file an affidavit. Mr. B.J. Mukherjee, Learned Counsel is present for the petitioner. Mr. I. Bhattakur, Learned Standing Counsel, APDCL, appearing for the respondent, submits that he has received instructions and therefore be permitted 4 weeks' time to bring the same on record in the form of an affidavit. Prayer allowed, let this matter be listed again after 4 weeks. In the meantime, affidavit on behalf of the respondents be brought on record. Let him file affidavit, then we'll.
Much of it. Lordship, in this case, the memo of charges has not been framed yet. That is my instruction.
So then the order of suspension will not survive.
I'll leave it to your Lordship.
No, what is your submission?
My submission is the memo of charges is not yet framed, Lordship. That is my instruction.
You are smiling. Smiling at whom?
Husband is there. I'd like to. So far as that. There is provision there for teams.
Where is the observation regarding Deepak Mali?
Paragraph 10 of Deepak Mali.
The judgment is there.
But this was considered in the division bench judgment by your lordship. The purport of that.
Yeah, that the court has observed that this is sub rule 6 of rule 10. Interpretation of sub rule 10 of rule 10. Yes.
The CCS, that provision is there. In the second page, Lordship will see paragraph 7, sub paragraph 7. Notwithstanding anything, any order made or declared shall not be valid unless or if not a period. That provision is not there in our.
But the Ajay Chaudhary judgment will be applicable.
I'm not opposing your lordship or arguing also.
No, there is nothing to oppose. We are not.
But what I'm submitting, what will this concern? Good, that is applicable.
We are not interested in granting an order to petitioner or respondent. We want to only do what is right.
Okay, what is the rule that is applicable? There are two kinds of stuff. One
Please come and argue that.
One in contemplation of departmental proceeding, and the second, it's a deemed suspension, Lordship. Lordship, so far as in contemplation of departmental proceeding, we are bound. It is obligatory for us to initiate the DP and issue a show cause notice, Lordship, or search it. But so far as deemed suspension is concerned, there is nothing obligatory on our part, Lordship, to initiate a departmental proceeding. So there is no requirement for issuing any memorandum of search it, Lordship.
So any judgment, Lordship, that discuss about issuance or non-issuance of search sheet, Lordship, in my humble understanding, Lordship, should not apply in case of the suspension, Lordship. But law has been settled. Our division bench has also passed order, Lord. So I'm not, we are complying that order as we have not filed any appeal, Lordship. My only point is, Lordship, in Ajay Kumar Chaudhary, while the Supreme Court passed the judgment in Ajay Kumar Chaudhary, Lordship, Supreme Court relied upon a judgment, a constitution bench judgment in Antule, Lordship. This should be DRS. Judgment to DRS in it? Ajay Chaudhary. Was paragraph 18, Lordship, page 299.
Paragraph 18.
Yes, Lordship, paragraph 18, page 299. So this conclusion of the High Court cannot be sustained in view of the following pronouncement of the Constitution Bench judgment in Antule. Lordship, I am coming to paragraph, page 300, Lordship, paragraph 5, down below.
No, it's not matching. I don't know which page.
We have the SEC, Lordship, SEC.
You have not given a list of books.
So we relied on this. The two books are, two printouts are there with your lordship. We have given the other day. And this we bought by abundant caution.
No, but the Ajay Chaudhary judgment, is it not relevant for this case?
Not we had it with us. This book we had got from the library. We had it with us. If need, we would have produced.
Mr. Banik, don't come up with all this. Who is
299.
taking the court proceedings seriously, it seems, huh? Earlier, people used to come prepared, ready with facts in their toes, tips, fingertips, books ready.
Page 299, Lordship, paragraph 18.
Mm.
So
Yes.
this conclusion of the High Court cannot be sustained in view of the following pronouncement of the Constitution Bench judgment in Antule. I'm coming to subpara 5, Lordship, in page 300.
Mm.
While determining whether undue delay has occurred, resulting in violation of right to speedy trial, one must have regard to all the attendant circumstances, including nature of offense, number of accused and witnesses, the workload of the court concerned, prevailing local candidates, and so on. What is called the systematic delay. It is true that it is the obligation of the state to ensure a speedy trial, and the state includes judiciary as well. But a realistic and practical approach should be adopted in such matters instead of a pedantic one. Lordship, this particular paragraph was followed by one of the judgment passed by our High Court. In WPC number 6842/2018, paragraph 100, Lordship. এখনো দেয়া আছে 6842/2018.
No, Mr. Nayak, I appreciate what you're saying, but please address the court on this aspect. You have rightly said that if a suspension order is issued in contemplation of departmental proceeding, then the department will be duty bound to serve a charge sheet or initiate a departmental proceeding in a time-bound manner. But when it is a case of deemed suspension, as in the present case, that 3 months rule will not be strictly applicable. It has to go by facts of each case.
Lordship, I'm submitting so far as deemed suspension is concerned, it is not obligatory for the government to initiate any departmental proceeding or to
Correct.
issue search it.
Correct, that's what I'm saying.
Lordship.
So what happens to the person then? Supposing he is arrested and then he is released after 3 days and the government will just sit over the matter because.
So it is 6.5, Lordship.
Huh?
Rule 6.5.
What is Rule 6.5? Let us see.
Page 6. Page 5, Lordship will get Rule 6, Lordship, suspension. Next page, it is 6.5, 6.5, Lordship. An order of suspension made or deemed to have been made under this rule may at any time be revoked by the authority which made or is deemed to have been made the order or by any authority to which that authority is subordinate.
So anytime would mean anytime.
On representation filed by the incumbent, Lordship.
So it may take 3 months, 6 months, 5 years, 10 years.
But
Anytime
if-
means
Lordship,
anytime.
If it is not there in the rule, Lordship, it is not there. That is my understanding, Lordship.
So that is why the law has been interpreted in Ajay Chaudhary.
Lordship, but that is what I am submitting, Lordship. If it is not obligatory under the rule for the department to initiate any departmental proceeding or issuance of a third seat, Lordship, then how a judgment which discuss the issue of issuance or non-issuance of a third seat be applied so far as 6.2 is concerned? That was
3
my
months, 3
understanding.
months, 90 days. 90 days from the
Lordship,
date
I'm
of
not
the-
arguing this case, that point, Lordship, because that judgment had, Lordship has already passed the judgment, so that issue is settled. I'm only on the point, Lordship, whether this 90-day period is to be taken as mandatory, Lordship, whether cannot it be delayed, Lordship.
appearance party.
So that is the only issue, Lordship, I'm submitting, and that is why I have placed that Antule judgments 0.5 and second judgment, Lordship, up to Rahman, Lordship, paragraph.
So in view of observations in para 13 of this Ajit Sanwal,
Lordship.
it has to be treated as 90 days with effect from the date of the order of
Yes,
suspension.
and the basis is that Deepak Mali judgment, Lordship.
Yes.
And Deepak Mali, Lordship, I'm submitting, this is my understanding. Deepak Mali, a specific provision was there in the rule, and court only affirmed that rule. And rule is quoted there, Lordship, in the Deepak Mali judgment. Lordship will, at page 2, Lordship.
Yes. Where is the Deepak Mali judgment?
Second page, Lordship.
Yes.
7, 2 to 3, 7.
What was Rule 10? Is it quoted anywhere?
Rule 10 is, yes, Lordship. The paragraph 2, Lordship, 10.6 and 10.7.
Just a minute. But in Ajay Chaudhary, para 21,
Lordship.
see, Deepak Mali's case, the court has just observed about.
What is
that
there in
This
the
was the
rule,
interpreting rule 10,
Yes,
sub rule 6, this is the view. But the following paragraph was interpreting in view of the court's, Supreme Court decision, which also includes the decision in Ajay Kumar Chaudhary. In para 21, where there was a order that beyond 90 days, if it is not reviewed, it will not survive.
No,
That was not,
so far as Ajay Chaudhary is concerned, Lordship, it is clear that this was a suspension under 6(1) in Ajay Chaudhary. That is the position, factual position, Lordship.
Hmm.
Issue before the division bench was whether Ajay Chaudhary is applicable in case of 6(2) or not. Court hold that it applies. So I maybe I'm satisfied or not satisfied. That is not the issue. Court held it applies. So I am bound
because
by.
in Rakibuddin, the court held that it
Yes,
applies.
yes. In Rakibuddin also it is there. So only issue now, Lordship, what I am arguing, Lordship, whether that 90 days period should be considered as a mandatory one or a preventive one, Lordship. That is my only issue, Lordship.
Unless that question is reopened, the larger bench, how can?
There may be, Lordship, that is why I relied upon this.
Then this is becoming a plaguing problem because the officials are kept under suspension for indefinite period and there is no good ground. Just that the authorities don't have time or inclination to look into it.
Lordship.
So that is one of the fundamental reasons.
What I am submitting, that is one Ajay Chaudhary judgment itself relied upon that Antule judgment, Lordship. One paragraph I have read, Lordship. One second judgment.
No, you are right on that. Facts will, all that the court is saying, do something about it.
Yes, that is there.
Let it not prolong by default.
Yes.
That's the law.
And in this case, Lordship, it's only 3 months. It is not delayed. It's not a case of 2 years, 3 years, 4 years,
What
Lordship.
are the dates? Let us get the dates.
Date of suspension 29th of September 2023. Or date of arrest 28th of September, first of all.
Page. Page
Date of
number.
Suspension is 55.
Date of arrest.
Date of arrest is 28th of September.
28/9/23.
Page 51.
28/9/2023.
At 9:30 PM. That is page 51. Suspension order, page 55. 29th of September.
Then when did you get bail?
31st of October 2023, page 56.
Page
56.
Then
My communication, 2nd of November 2023, about my bail. That is in the additional affidavit, annexure A, page 74. 2nd of November 2023. Additional
communication, page 74.
page 74.
Dated
2/11/2023. And my statutory appeal is at page 68. That is 18th of November 2023.
of February.
November.
So what is your basic submission?
My basic submission is that since by the judgment of Ajit Sonwal, my lord has held the.
Which paragraph in Ajit Sonwal?
Ajit Sonwal, my lord, paragraph 13. It to be axiomatic, my lord, self-evident. From careful analysis of the above decisions of the Supreme Court, what follows that unless review is held within 90 days, an order of suspension, including one issued due to detention of an employee in custody for 48 hours, would not survive, nor can such an order be granted fresh lease of life by carrying out a review after expiry of 90 days. In view of the law laid down in the case of Deepak Mali Supra and Ajay Kumar Chaudhary Supra, it is axiomatic that the order of suspension dated so and so had lapsed after expiry of 90 days due to want of review by the same by the disciplinary authority. We therefore find ourselves in agreement with the findings recorded by learned single judge in the improved judgment order. This is our case.
So, and your instruction is no charge sheet till today and the order has also not been reviewed.
90 days from date of suspension would expire on 28th of 28 December 2023. And by abundant caution, may not, assuming but not admitting, date of some information 2/11 is taken, then 31st January 90 days is over. Then also.
One paragraph only, from which date it is to be counted, Lordship. Manual of departmental proceeding, page 61, Lordship. Page 61.
It is in this book.
Yes, Lordship. Page 61, 2.2.7. 61, 2.2.7. It shall be the duty of the government servant who may be arrested for any reason to intimate the fact that his arrest, of his arrest and the circumstances concerned therewith to his official superiors promptly, even though he might have subsequently been released on bail. On receipt of the information from the person concerned or from any other source, the department authorities should decide whether the facts and circumstances leading to the arrest of the person call for his suspension. Failure on the part of the government servant to do so, inform his official superiors, will be regarded as suspension of material information and suppression of material information, and will render him liable to disciplinary action. This is other issue, Lordship. So far as first information part is concerned, Lordship, department will come to know that he is not under custody, Lordship. He has been released from custody, so his release statement can be considered. That is why the information is necessary, Lordship. So,
But he has given that information on second.
on second, Lordship. So that 90 days period only,
See,
Lordship.
Mr. Nayak, the only issue here is what happens to that order of suspension. We are not saying what else you can do, whether you again can place him under suspension, you can, but there has to be a purpose behind what you're doing.
Lordship.
It appears that the department is treating suspension as a as a mode of penalty itself.
Now it is not going on in all the departments. In some departments, some lackings are there, Lordship.
That's
It
the
is
point.
there, Lordship, no doubt.
If you want to proceed against it, proceed. No, who is stopping you?
Even the chief secretary has issued notification to each and every department, Lordship. Do this
So
immediately.
even if the court interferes with the order, we'll make it clear that you are free to proceed against the in accordance.
So my only submission will be, Lordship, one more chance be granted to the department, Lordship. So granting 7 days, 10 days, whatever,
No,
Lordship.
but the department is not
If
asking.
even after they do not go for review, Lordship, then Lordship will interfere. That much only, Lordship. And one judgment, Lordship, that is why I'm reading, Lordship. Just one paragraph in Abdur Rahman, Lordship. Same thing, Lordship. It should not be taken as parenting in a parenting manner. It may be granted. Means that even after a lapse of 90 days, it will not be automatic reinstatement. That has been held in this judgment, Lordship. So it's up to your Lordship.
Order has gone. That will clarify. Rest, whatever else is, we'll see. Order has gone, the law has to be uniformly applied. When it says order lapses after 90 days, means it lapses.
That is,
That we
that is
can't.
I am not arguing that for.
It lapses under 90 days, but for him, it could be 92.5 days. For him, it could be 90. That kind of judgments the court cannot pass.
Lordship.
But as I've said, if the department is really serious about taking action against the petitioner, that option will always be open for them. What is the problem in taking any action against him as per the rules? You do it if you want to do it.
Lordship.
Who's stopping you? In Ajit Borgohain also, Ajit Sanwal also,
Sanwal.
there was no embargo. We don't know what action has been taken. The department says we place him under suspension, we will not review it. And court cannot tell us to do it. That argument will be difficult to accept. You want to do it, you do it. They are your employees. What is stopping you from doing? Fact remains that maybe your officers are too busy or too reluctant to apply their mind. He's there, let him be under
Lordship,
suspension.
that may be one reason, Lordship, other reasons may also be there, Lordship. They are all colleagues, Lordship. They are all sitting next to each other, Lordship. That reason may
There
also
will
be
be
there,
higher authorities, no?
Lordship.
Suspension cannot be issued by colleagues.
In
Order of
case of
suspension
them,
is
yes,
issued by the disciplinary authority. And this is a serious matter. Serious matter. But what is not correct is not correct. Anyways, I'll go through the record and pass an order. You may get it tomorrow.
Lordship. Obliged, Lord.
Yes, that's all. Give these books. Whose book is this?
I got it.
Give me this book.